May I, Your Lordship? Lordship, I beg to mention item number 11 and 12, Your Lordship. I've taken concern, Your Lordship, from the petitioner side.
Why do you need time, madam?
Uh,
Why do you need time?
Oh, in this matter, AAG R.S. Nabam is appearing, Your Lordship. So he instructed me to adjourn this matter.
Affidavits filed?
Yes, Your Lordship, we have filed.
Yes, when?
15, madam.
15.
15th.
11.
Just tell us the date, 15th.
Yes, 15, Your
On a
Lordship.
request made on behalf of the R.H. Nabam learned AAG. Matter is adjourned to be listed on 15/6.
6, Your Lordship.
3 J. Saring, learned counsel for the petitioner is present.
Grateful.
Separate orders, huh? Matter, I said it's singular, separate matter. 11 and 12.
Yes, and also, Your Lordship, item number 15, Your Lordship, same, Your Lordship.
15.
Yes, Your Lordship.
He is appearing on behalf for Mr. Nabam.
Yes, Your Lordship.
For the petitioner.
Okay.
Matter may be taken up on 16, my lord.
16th.
Yes.
Same, huh?
Yes.
On 16. Item number 15 will be on 16/6. Then for the petition, you write, Ms. N. Duncan, learned counsel for petition is present.
Oblige, Your Lordship.
May I, my lordship, I beg to mention item number 7.
Yes, please.
This matter will be listed on 10th June, my lordship. I have taken consent from the petitioner. Item 7.
On behalf of
7.
the government,
Yes.
on a request, Ms.
Otherwise,
District matter is adjourned to be listed on.
Tenth.
otherwise we may try day after tomorrow also, Wednesday.
Let it be on 10/6. 10/6.
Oblige. Hi, Lordship. Lordship, I would like to mention unlisted matter. WPC number 154 of 26. My lord, this matter may be listed for tomorrow.
Tomorrow.
Yes, ma'am.
What is the urgency?
My lord, it was supposed to be listed on 27th of May. And
What is the stage of the matter?
filing of affidavit by the respondent.
Filing of affidavit.
Yes, ma'am. Earlier 2 occasions, it was already passed for the filing of
Tomorrow,
affidavit.
the DB. Okay, we can try.
Okay.
My lord, this item number 29 to 34. My lord, in 29 they have filed an IA. IA is on for implement, my lord. My lord, as such, I have gone through. My lord, they are not against us as such. So, my lord, may I just take instructions from my client? And these other cases are fixed on 15/6. So this can be taken up on 15/6.
For the IA,
I'll inform Mr. Kamduk.
is he there? Have you informed him?
I will inform him.
No, you have to inform him first. He has listed the IA. In his absence, we cannot pass any order.
Okay.
We'll accommodate you, let the matter reach. And if you get him now, you can come back immediately.
Okay.
May I please, Your Lordship? Your Lordship, I beg to mention one unlisted matter to be listed tomorrow, Your Lordship. This matter was listed last on January.
Why tomorrow? Tomorrow, there's the DB. Have it on Monday. Monday.
Your Lordship, then on Friday, Your Lordship.
Friday would be the last day. We not know what will happen on Friday. Okay, you try on Friday. What is the matter about?
Your Lordship, the petitioner is prejudiced by the promotion of the private respondent who doesn't qualify for the
So you
post
cannot
of
dispose of a matter on this kind of matter. Have it on Monday. Okay, on Friday we'll try. Okay,
Yeah.
Friday we'll try.
much of it.
May I please, my lord? My lord, I beg to mention item number 37, my lord.
37 years.
Yes, my lord. As prayer by the petitioner, the matter may be listed after 2 weeks, my lord.
18 matter.
Yes, my lord.
2018 matter.
Yes,
We are
my
not
lord.
adjourning.
The petitioner is from the Guwahati-based
We
advocate,
will
my
not
lord.
know. 18 matter we are not adjourning in 2026. Sorry. Yes.
My lord, Mr.
Yes.
Kamduk is here.
So there's a
We'll fix it on 15th.
other matters are listed on 15th. Can we have this on 15th?
Yes.
Okay.
Otherwise, this I is for this.
He has said
Yes, my
he
lord.
does not. Or we can do one thing. We can pass orders on this and list it on 15th.
My lord, I'll just for my, at least I need to consult my clients, at least for once, because paper was given to me yesterday in evening.
The party learned counsel for the opposite party has submitted that the connected writ petitions are to be listed, are directed to be listed on
15-6.
15/6. So he accordingly pays for adjourning the present application to be considered on 15/6. But also heard Sri D. Kamduk, learned counsel for the applicant.
Yes.
Para, in view of the above, matter is adjourned to be listed on 15/6.
Obliged,
It will be on 29, 30,
up to 34, my lord.
up to 34.
Up to
36.
35, up to 36, no, the 35, up to 35.
34,
Up to
34.
34.
Okay, yes,
35 is different.
obliged.
My lordship, I beg to mention item number 20.
20.
Yes, your lordship. Leading counsel is out of station, may be listed after 1 week.
Who is your counsel?
Sunil Mao. I'm for the petition.
On a request made on behalf of the petitioner, matter is adjourned to be listed when?
After 1 week, your lordship.
Listed, we give a date. Listed on 15th of June,
Much obliged.
15/6.
Item number 1.
Met, please, your lordship.
Yes.
Well, the matter relates to my lord transfer, my lord. After serving nearly 4 years in the district of Lohit as DFO, I have been my lord transferred to Likavali on 13/10/2025. And pursuant to that order, my lord, the order would be effective only after 31st of March 2026. Now I have joined on 2/4/26. Joining report is also submitted. Charges are also taken over. And the incumbent who was serving in Likavali has proceeded to his place of posting. Now, all on a sudden, my lord, this order, my lord, impugn order 18/5/2026 that came to be passed and absolutely nullified, my lord, at the behest of the respondent number 8, my lord. And by an additional affidavit, my lord, I have my lord, placed before the honorable court the RTI information. That's a part of the record which were supplied to me. Affidavit has been filed by the private respondent. I have also submitted the reply. Now, government perhaps, if the records are there, it may take up for the disposal also. I am on the verge of retirement, my lord, hardly 1.5 years to go.
Yes, you have the
Lordship,
records.
yes, Lordship.
We can take it for final disposal.
Lordship.
Today we can take it up.
Yes.
Yes, Mr. Saikia, what is the case?
Lordship, my lord. Now, Lordship, may kindly come to my lord, page 28.
28.
28. This is the order of transfer.
Just a minute. What do you do?
My lord,
Who are
serial
you?
number 1. Well, I am, my lord, I am otherwise, my lord, SCF, and my lord has taken the charge, taking the charge of the DFO at the, my lord, Lohit. And now
You took
has been, my lord, transferred here, my lord, to Likavali.
No, what post do you hold?
Yes, yes.
My lord, the substantive
post do you
post is
hold?
my SCF. And also the charge of the DFO, my lord, of Lohit district, I was taking, my lord.
Right, okay.
Private respondent is
Then,
also SCF. my lord.
Who is the private respondent?
Private
Name?
respondent is respondent number 6, my lord. Here, Lordship will find it serial number 4.
Gopal.
Goba Doke. Goba Doke.
Gopal, okay.
Lordship, my lord. I am at serial number 3. I have been, my lord, transferred to DFO Likavali. And person at serial number 1,
This is dated what? 28 is dated.
13/10/2025. Lordship.
Petitioner transferred from
DFO Lohit
Hmm.
as DFO Likavali.
Lohit to Likavali.
Likavali.
Okay.
Now
Thereafter,
person at serial number 1, he is from Likavali to Devmali.
okay.
And serial number 4, respondent number 6, he is from Bandardeva as DFO Sagali.
Okay.
Now in column 5, your lordship will find the orders are to be effective from 31st of March 2026.
Okay.
Now by the next page, my lord, this is my joining
After,
report.
not with
After,
effect from after.
After, my lord, after 31st March 2026.
Okay. Then,
My lord, by next page, my lord, page 29, I have joined in the post on 2/4/2026, which has been duly acknowledged and forwarded by the incumbent who was there in the, my lord, Likavali.
you joined it,
He has
Likavali.
Likavali. He has forwarded to the, my lord, Chief Conservator of Forest.
Okay. Yes.
He has forwarded it to, my lord, and I have also, my lord, at page 33, I have intimated the respondent number 3, my lord, Principal Chief Conservator of Forest, that I have taken full charge of the post, my lord.
33.
Page 33, my lord.
Handing over, taking over.
Lordship,
Taking over charge. 33.
33.
Okay. Okay.
Lordship. Now, my lord, next page, this order comes, my lord, at page 34, impugned. It is dated, my lord, 18/5/2026. Now, by this order, page 34,
Date of the order.
page 34, my lord, serial number 1, that is respondent number 6,
Date of the order.
my lord, 18/5/2026.
Okay. Now, what is there in 34?
34, lordship will find serial number 1, that is respondent number 6. He has been transferred from Sagali as DFO Likavali, where I am serving. And at serial number 2, in the second column, lordship will find I have been retained as DFO Lohit Westland, where from, my lord, I was transferred earlier to Likavali and I have taken over charge. And the remark column, it is said in partial modification of order issued by the order dated 13/10/2025. Well, my contention is, my lord, the order having been complied with, already executed by all the incumbents, there nothing remain to be modified. Authority may pass a fresh order on fresh consideration in public interest or exigency of service, but not, my lord, modify an order which already has spent its force. Now I have submitted the representation also, and, my lord, I have come to know as the respondent number 8, who is the, my lord, local MLA of Likavali, and the private respondent number 6,
Your representation is at page 36.
Lordship, my lord. This has not been, my lord, answered till date, my lord. Details I have given.
Yes.
Now, it has come to my knowledge, my lord, that the respondent number 8, who is the local MLA and also the deputy speaker of the assembly, my lord, and the private respondent number 6, he is also a, my lord, local resident of the Likavali. And because of that, my lord, he has opposed the MLA and the MLA has, my lord, written for modification of the order. Accordingly, my lord, this came to be passed without, my lord, having any public interest or, my lord, exigency of service. There is absolutely no allegation also against me. But I have filed an additional affidavit on 27/5/2026. I have submitted an RTI application for supply of the, my lord, documents. Now, if your lordship may see at page 56.
Yes.
This is the note of the, my lord, deputy speaker, my lord, and the consideration on which, my lord, he has sought for, my lord, posting of the private respondent number 6. May I read, my lord? Sri Bajun.
Yes.
Taba APFS DFO Likavali Forest Division Lower Siang District has been transferred and posted at Deomali Forest Division via order number so-and-so dated 13th October 2025. In this context, I am to apprise that Sri Goba Doke AFS DFO is hereby recommended for transfer and posting as DFO Likavali, Lower Siang District. He is a native of Likavali and is well acquainted with the people and environment of the region. His posting at Likavali is expected to be beneficial to both the local populace and department. It is also mentioned that he is on the verge of superannuation by the year 2027 and has presently been transferred to DFO as DFO Sagali by order number so-and-so dated 13th 10/2025. In view of the above, the consideration of the convenience of the incumbent officer, Honorable Chief Minister so-and-so is earnestly requested to kindly direct the authorities concerned to initiate necessary action to change the transfer and posting of Gobadoke APFS DFO Sagali. Well, here, this letter is absolutely silent.
Private respondent is also on the verge of retirement.
Yes.
Yes.
Well, yes, madam. According to him, 2027, I am also retiring in the first part of the 2028. 1 year, 1.5 years to go. And my native place is Basar is about 70 to 80 kilometers from Likavali. Now, this is absolutely silent with regard to the execution of the this posting that the incumbent of the Likavali has already left, and then I have joined. And then your lordship may come to the next page, 57, serial number C. Under note received from the Deputy Speaker dated 28/10/2025 requesting for transfer and posting of Sri Gobadake from DFO Sagali FD to DFO Likavali FD. It is informed that the incumbent DFO Likavali FD Sri Taba is transferred and posted to Deomali Likavali FD with effect from April 2026. Also, Sri Katobasa has been transferred and posted from DFO Westland Division to DFO Likavali FD with effect from April 26 under order dated 13/10/2025. Subsequently, Sri Talok Rime has been transferred and posted from DFO Aneni FD to DFO Westland Division by Sri Katobasar, which means with effect from 26. Sri Amarjit Kaur has been transferred and posted as DFO Aneni FD by Tirame. So in my post, this Talok Rame has been posted, madam. Then Lordship may Come to the next page, my lord, note number 90. Please resubmit with the detailed posting profile of APFS officers in the state. Then Lordship may come to my note 95. The second paragraph, rather third paragraph. We may for the present consider the posting of Sri Keto Basar, who was earlier ordered for Likavali division to Sagali division. Well, this is wrong, my lord. I was never, my lord, ordered for Likavali division to Sagali division, and post Sri Gobadoke, who is presently holding Sagali division as DFO, Likavali Vice B Taba, who is under order of transfer to Diamali. I was never proposed for Sagali. Rather, I have been retained at the DFO Namsai. And accordingly, a posting order has been prepared. Next page, page 60, note 98. Here, the respondent number 6 at serial number 1 has been proposed as the DFO Likabali. Then myself at serial number 2 to be retained as ACF in charge mobile so and so. Then Lordship may come to note 100. May be considered for approval provided that officers at serial number 2 and 3 have not joined their place of posting. That is 2 and 3 means, my lord, it is me and my lord Amarjit Kojur. And this note is of my lord 28/4/2026. Whereas I have joined on 2/4/2026.
Okay.
Then Lordship may look at the note number 106. In the context of note 100 above, please furnish the present status officers at serial number 2 and 3 of note 98.
Yes.
Then, my lord, details has been given note 107. That present petitioner serial number 1. The officer was transferred and posted from DFO Lohit Westland Division to DFO Likabali Abdi by order dated 13/10/25. The officer has joined and taken over the charge of DFO Likabali Abdi by joining report dated 2/4/2026 and charge and certificate of transfer dated 30/4/2026. Further, no relief order in respect of officer has been received for either ACF Mobile Squad Mahadevpur or DFO Waterland Division from CCF ESC. Then Sri Amarjit Kojur IFS. Amarjit Kojur has joined the office of DFO Anini FD on 6/1/2026, but no CTC or handing taking over charge of DFO has been yet received in the office. So he is, though joined in Anini, he is not there in the Anini. Now rest of the notes, my lord, no comments. And note, my lord, 112. Directly when I'm referring to the note number 98, that is the proposed transfer order requested for, my lord, approval by the Honorable Chief Minister. And accordingly, that has been, my lord, approved on 13/5/2026.
Yes.
And then, my lord, the impugn of order came to be passed. So Lordship has seen the, my lord, entire record, my lord, so far as my lord, with this affidavit. There's no exigency of service, my lord. There's no public interest. The only interest is that the respondent number 6 is a resident of Likabali and he knows the local people. So therefore, he'll serve better. There's no allegation against me also. There's no comparison that he'll be doing much better than me, etc. And I have joined on 2nd, and then this order came to be passed, my lord, after, my lord, 45 days.
Yes,
So
that's all.
basically, my lord, that's my lord, the two count, my lord. The firstly, my lord, the order dated 13/10/2025, 26 having been 25 having been executed. Nothing remained to be modified, my lord. My lord, there's two of the, my lord, High Court judgment, of course, not the Supreme Court, my lord, that I'd like to place, my lord. One is of, my
Yes,
lord,
please do.
my lord, Counsel, my lord, Taba may supply the
Yes.
copies, my lord.
What are the
One is-
citations?
My lord, these are downloaded copy from the, my lord, websites, my lord, official websites.
Name.
My lord, Torun Karun Kanango versus State of Chhattisgarh. It's only one page judgment, my lord. And the
Chhattisgarh High
second
Court.
one,
Which High Court?
my lord, it is of the, my lord, Chhattisgarh High Court.
Why don't you place some Guwahati High Court or Supreme Court? Why are you placing judgments of Chhattisgarh High Court?
Lord, my lord, actually, because of hardness, I could not find, my lord, immediately.
If you want to place judgments, there are a number of judgments on
Lord,
transfer.
it is
Okay,
done.
not required. Okay, that you have understood your case. Yes, Mr.
And
Lawson.
then,
Anything
my
more,
lord,
Mr. Saikia?
and another judgment, my lord, AIR 2001, Supreme Court 2524, that is Tiroshan Dev Sharma, my lord.
2001 Supreme Court
24.
Name.
That is, my lord, paragraph 15, my lord.
Name.
Name
Yes.
is, has you also got the name, Tarol San Dev Sharma?
Solution. Which paragraph?
Paragraph 15, my lord.
Can you just read?
Yes. It's basically the higher officer, my lord, they cannot at the, my lord, pressure of the or at the behest of the, my lord, politician can, my lord, volition or decision making or my lord, can be, my lord, pushed back, my lord. Paragraph 15. In the system of Indian democratic governance, as contemplated by the Constitution, senior officers occupying key positions such as are not supposed to mortgage their own discretion, volition, and decision-making authority, and be prepared to give way or being pushed back or pressed ahead at the behest of politicians for carrying out commands having no sanctity in law. So, my lord, here exactly that has happened, my lord. The secretary or the higher, my lord, advisor has sought that this may be possible if the persons have not joined. And while the record also reveals that the order dated 1310, my lord, has already been executed, persons have joined, then also, my lord, ignoring those, my lord, the minister having approved, so secretary has passed the order. These are three judges, my lord, bench, my lord. That's all, my lord, that is my submission.
Yes.
Lordship, super transfer posting is concerned, Lordship. Since the Lordship, the transfer posting is the conditions of the service, Lordship. One can be transferred within a month, 2-3 transfer also can be made, Lordship, subject to that is in the interest of public, Lordship. That's a law, Lordship.
But normally after how long?
Normally, Lordship, as per our state policy, Lordship.
2 years.
2 years, yes.
2 years.
2 years, Lordship.
2 years is the norm.
Yes, Lordship. But that does not give the indefeasible right to the Lordship.
And obviously, but what is the objective of this transfer?
Lordship.
Apart from the note of the Deputy Speaker,
Lordship.
is there anything else in this transfer?
Lordship,
We have gone through the note sheet.
not said, Lordship.
Are there any other materials which had led you to passing of the impugned order?
No other materials.
Then
The transfer posting order, Lordship, basically is Lordship in violations of statutory rules, Lordship, or malpractice, Lordship. Here, Lordship, the violation of statutory rule is not there, Lordship. and that they part the Malapadi lordship. The Malapadi,
The violation is not there. It may not be an indivisible right, but the normal expectation of 2 years is there.
but lordship see,
The
Or
people
lordship-
transfer unless there is a public requirement, public interest. Why do you transfer?
lordship see the lordship not of the honorable MLA lordship.
Yes. So what will happen to the petitioner? MLA has thought about his person. Who will think about this?
Petitioner also, he has not completed 3 years in the, 2 years in his last posting place lordship.
That was not. That was not challenged by anybody.
That is,
Now,
since he has,
while thinking about the private respondent,
lordship,
there is no consideration on the petitioner's whether he is agreeable. If at all, it could be done a mutual transfer. He is not agreeable.
lordship, that is the, that's why I'm submitting lordship. They have not completed their lordship 2 year and normal tenure in their respective posts.
Earlier,
Yes, lordship, last posting.
last post, but that is not the subject matter
Here,
for us.
That is correct, lordship, but what the mind of the authority.
Is it the consideration that because you have not completed
No.
2 years, so we send you?
No,
back?
no, that is
So please do not make those submissions.
lordship.
Please do not make those submissions which are not reflected in the records. We
That-
are not
that-
going to accept those.
That is,
And rather, we would ask you not to make those submissions.
then
To
lordship,
invite this court to make some remarks against you.
lordship, the mind of the lordship authority, lordship.
Mind of the authority is reflected in the note sheet. Show us any materials. If there is anything else, we will definitely consider. This cannot be done like this. Somebody wants a favor. Yes, you favor. Think about the other person also.
Lordship. In that case, lordship, just I'll place on citation, then I'll leave the rest to
Yes.
this normal court, lordship.
Which one?
Who will
How do you modify a transfer order which has been executed?
lordship.
You can pass a fresh transfer order. That can be matter of challenge. That's a
Yes.
different matter.
That part,
How do you modify? You already joined. You have accepted. What is this?
this is lordship,
Pulilombi.
who will lordship. Here also, lordship, the transfer was lordship issued. Basing on the note issued by the honorable MLA, lordship. Kindly see the paragraph 1, lordship. To understand the case here, lordship, paragraph 1,
Paragraph 1.
lordship. Just to understand the lordship case, lordship. Mary,
Paragraph 1.
lordship.
See, Mr. Tapin, this law is very settled now.
Yes,
In Abbas case, if
Abbas case.
accommodating is possible,
possible.
but not at the cost of somebody who is aggrieved. If it is done without anybody being aggrieved, it is permissible. Now, here is a case, somebody has come before the court.
Lordship.
If there was no challenge, this matter would have been settled. Now, the matter has not settled down. He is aggrieved. Why he is aggrieved? Because after joining, you pass immediately. You could have passed modified before he joined. Then also, if he challenges, that's a different matter. Then he could have very well taken up the point. See, you have not even completed 2 years at Likavali. So your transfer was done. So we intend to keep you at least for 2 years. Or whatever. Your discretion, we are not questioning your discretion, but
Yes.
discretion has to be necessarily be accompanied by bona fide. Bona fide not only for the person who is the beneficiary, bona fide for the person who are all affected by this order.
Lordship. In this particular case
Yes,
also.
madam. You have to stay for some time. You file another application to be considered if you are in the
Madam,
verge of retirement.
My lord, before that, my lord, that note sheet, my lord, there is something I'd like to point out, my lord.
Yes, please.
That note sheet, which was initiated according to them allegedly at my behest,
Phone number
6,
R6.
yes. This note sheet, it appears at page 56, Was-
R6.
yes, of the additional affidavit,
Yes.
October 2025.
although in the meantime, before this final, in the meantime, before this final decision to modify the transfer order was passed, the petitioner had joined. But initially, when it was initiated, because the transfer order, I would say the first transfer order, 1310-25, was to take effect after
1st of March.
after 31st of March.
Yes.
Well before that, these things were done. I mean, this North Sheet was there. So that time he would not have been affected. But of course, it is maybe due to some delay. This
Your submissions would have certain value if this note sheet
Yes.
process which was started before giving effect to the transfer order for after 31st.
yes,
The
It is only-
expression is that we have noted not with effect from,
yes,
after.
yes. After 31st of March.
If the modification was done
Yes.
before 31st.
What I'm saying is the initiation of that modification.
cannot do.
That time it was,
Initiation, he may not be even aware of this initiation.
my lord.
You could have put the transfer order to hold. Not you, the government,
Yes, my lord.
that we are under consideration, keep it on hold.
My lord, my learned.
After, and what is also more important
Yes,
is that there is a note at 107
yes,
that the petitioner has joined and taken charge. Come to page 61.
yes. I've seen that, my lord.
There one more note,
Yes.
61.
Petitioner has joined and the other person, Kujur, one IFS, who was to be posted in his place, has also joined but has not taken charge
Yes.
of Anini.
Then see at 100.
Yes,
See at
100.
Not 100.
That is the advisor.
May be considered for approval provided the officers at serial number so and so have not joined their respective.
This is, my lord, by the advisor to my lord, the minister.
Nonetheless,
Yes,
there's a-
yes.
There's a recommendation.
And it is not that the respondent aid, that is the MLA. It is not that it is, he has done everything. It is not, it has gone through several levels, finally to the Honorable Chief Minister also. So it is not,
We are not attributing any malafide against the petitioner.
yes,
Was the petitioner's case considered while making all these movements?
yes.
It was not considered.
No, my lord. What I'm saying is, it has gone, this, my lord, this decision is not merely due to the MLA. What I'm saying is, it has gone,
If you remove the letter.
Yes.
MLA,
yes,
will the decision be there? They were saying, madam, this is the foundation of the decision.
yes, my lord.
Remove the letter, where is the decision?
My lord, I would also like to rely on Pubilombi's case. Here, my lord,
Pubilombi has
yes,
considered the earlier, Abbas you can side.
yes. In Pubilombi is also almost the same, my lord, almost on the same facts, my lord.
Okay,
Facts are in facts are in paragraph 2 and 3, my lord.
matter of, we will allow this.
My lord.
Third, we PJ Secretary Senior Council, who is appearing online, assisted by
Titaba.
Titaba, who is physically present. Also heard Sriya Stapin, learned Senior Advocate, Arunachal Pradesh, full stop, Miss Ann Dangan, learned counsel is present for the response number 6, full stop. The challenge in the instant writ petition is against an order dated
18/5/26.
where's the order page?
Page 34.
Order dated
Sorry.
18/5/2026, whereby the response number 6 has been transferred from Sagoli, what do you call Sagoli division? Sagali.
Yes.
Sagoli division.
Family Forest Division.
Sagoli Forest Division to Likabali Forest Division. And the petitioner has been sought to be retained as Lohit Division, full stop, para. As per the facts projected, comma, the petitioner who was working as ACF, who was holding the substantive post of ACF, was also the in-charge DFO of Lohit Division. Full stop. Wide and order dated 13/10/2025, the petitioner was transferred from Lohit Division to Likavali Division. Full stop. Wide in the same transfer order. No, why the same transfer order, comma. The respondent number 6 was transferred from Bandardeva to Sagali Forest Division. Full stop. There was, however, a remark in the order that the same would take effect after 31/3/2026. By the said transfer order, comma, 2 other incumbents were transferred. Full stop. It is the case of the petitioner that after the stipulated date of 31/3/2026 was over, comma, he had joined at Likavali by submitting joining report on 2/4/2026, and the same was forwarded to the appropriate authority. Full stop. On 6/5/2026, comma, the petitioner had made a communication to the principal chief conservator of forest, Arunachal Pradesh, intimating that full charge was taken over by him. Full stop. However, comma, wide the impugned order dated 18/5/2026, comma, the petitioner has been sought to be retained at Lohit, and the respondent number 6 was sought to be transferred from Sagali to Likavali. Full stop. Para? Oh, no, don't pay. The order, the impugned order had mentioned that so far as the petitioner is concerned, comma, there was partial modification of the earlier order dated 13/10/2025. So far as the petitioner, so far as the parties are concerned, not petitioner. Para. 3. Saikya, the learned senior counsel, at the outset, has submitted that the order dated 13/10/2025 was already executed, and the petitioner had admittedly joined at Likavali on 2/4/2026, and therefore the question of modification of the order dated 13/10/2025 would not arise. Full stop. Para. On the merits of the case, comma, the learned senior counsel has submitted that though transfer is an incidence of service and the scope to challenge is limited, comma, such challenge can be made if such transfer is not accompanied by bona fide and following the rules. Full stop. He has submitted that normally the tenure is of 2 years. Full stop. However, in the instant case, comma, apart from violating the requirement of tenure, comma, the background would reveal that the impugned action has been taken only at the behest of the local MLA and deputy speaker, who has been arrayed as respondent number 8. Full stop. The learned senior counsel has drawn the attention of this court to the additional affidavit filed, wherein the notes, office notings have been enclosed, which have been procured by RTI. Full stop. He has referred to the notings wherein the movement had started on a recommendation by the respondent number 8 to accommodate the respondent number 6. Full stop. The learned counsel, senior counsel, has submitted that while the respondent number 6 can may be favored, comma, that cannot be done at the cost of the petitioner and by violation of the rules, full stop. He has submitted that there is a note that the proposal given by the respondent number 8 can be looked into, provided the incumbents had not joined, full stop. He has also drawn the attention of the note number 107, wherein there is a clear reflection that the petitioner had joined and taken over charge, full stop. However, in spite of all the notings, comma, there was an approval by the highest authority leading to passing of the impugned order dated 18/5/2026, full stop. Para. The learned senior counsel has submitted that the impugned order has been passed without there being any exigency of service or without there being any requirement of public interest, full stop. He has also highlighted that there is no allegation of any nature against the petitioner requiring his transfer, full stop. The learned counsel, senior counsel, has relied upon the case of the Honorable Supreme Court reported in AIR 2021 SC 2424, Darlochan, and the following observations have been pressed into service, para 15 quote. Per contra, comma, defending the impugned action, comma, 3S Tapin, learned senior government advocate, has submitted that posting for a period of 2 months is only a norm which will not give an indefeasible right to an incumbent. He has submitted that a transfer on the basis of a note of a public representative per se cannot be held to be illegal, as the note had taken into consideration certain relevant aspects, including the aspect that the respondent number 6 was at the verge of his retirement and belonged to Likavali. Full stop. He has relied upon the case of Pubi Lumbi versus State of Arunachal Pradesh, reported in 2024, 12 SCC 292. Para. Ms. Dungan, the learned counsel for the respondent number 6, while endorsing the submissions of the learned state counsel, has submitted that there was a stipulation in the original order of transfer dated 13/10/2025 that the same would take effect only after 31/3/2026. Full stop. He has highlighted that the present process for which culminated in the order dated 18/5/2026 had started long back, more specifically on 28/10/2025, which would be reflected in the note sheet. Full stop. She has accordingly submitted that the impugned order does not suffer from any illegality. Full stop. She has also submitted that relevant factors were taken into consideration, which led to passing of the impugned order dated 18/5/2026. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Para. It is a settled position of law that transfer being an incidence of service, comma, the scope of interference is limited, and only in case of violation of statutory rules or presence of malafide, comma, such orders can be interfered. Para. The original order of transfer dated 31/10/2025 had stipulated that the same would take effect after 31/3/2026. Full stop. It is not in dispute that the petitioner who was at Lohit had joined his new place of posting at Likabali on 2/4/2026. And there are further communications to fortify these aspects. Full stop. However, on 18/5/2026, the impugned order has been passed by which the petitioner has been sought to be retained at Lohit. Full stop. This court finds force in the contention advanced on behalf of the petitioner that after joining in terms of the earlier order dated 13/10/2025, there was no scope for modification of the earlier order. Full stop. The matter would have been different if a fresh order was issued, which however would also be subject to judicial scrutiny if so instituted. Full stop. The reasons for passing the impugned order are placed on record by way of the additional affidavit in the form of the office notings, which are also not disputed. Full stop. It is not in dispute that the process started with a recommendation by the respondent number 8, who is the local MLA and deputy speaker. Full stop. While such recommendation per se may not be termed to be illegal, the aspect of compliance with the norms and also the public interest cannot be overlooked or ignored. Full stop. In the instant case, the impugned order has been passed after within a span of 1.5 months from the date of joining. Full stop. There is no element of public interest involved in the aforesaid transfer, as the same was done only on the note of the respondent number 8. Full stop. The office note would also reveal that there was a stipulation that the proposal would have been acted upon if the incumbents had not joined. And subsequent office notes would indicate that the petitioner had indeed joined in the new place of posting at Likabali. Full stop. That being the position, there was no occasion to pass the impugned order dated 18/5/2026, even though there was a recommendation, public request by the respondent number 8. Full stop. This court makes it clear that while there may not be an absolute bar for a public representative to make a recommendation or request, such recommendation can be acted upon only when public interest is there and it is not done at the cost of any other incumbent. Full stop. Para. So far as the case of Pubi Lumbi Supra is concerned, the Honorable Supreme Court, relying upon the earlier cases, including the case of Union of India versus S.L. Abbas, within bracket 1993, 4 SCC 357, has laid down that, has reiterated that public interest and lack of mala fide has to be the basis of any transfer order. Full stop. As observed above, the impugned order does not appear to have been passed in the public interest. In view of the above, this court is of the opinion that a case of interference is made out. Full stop. Accordingly, the impugned order dated 18/5/2026 is interfered with and set aside. Full stop. Yes.
Obliged.
I think in the submission of Mr. Tapin, that would have been 2 years instead of 2 months. I think I heard 2 months.
2 years.
Yes, 2 years.
2 years we have said. We will look at it.
Lordship, apart from that, Lordship is setting aside the inter-transfer order.
No, the the interference is only with regard to the transfer of the petitioner.
Yes.
No, my lord, in that case,
Because it affects the inter.
two more persons will be affected.
No, we'll make it clear, we will not interfere with, and the petitioner shall be allowed to continue at Likabali.
Lordship may observe, Lordship, in respect of the race, Lordship, officials, Lordship, the authority will make necessary arrangement.
Why should they observe?
Because in that case, Lordship, if this is set aside, Lordship, they
Because
go.
It is also, the authorities are given liberty that without disturbing the petitioner, appropriate arrangements may be made to accommodate the other officers.
They will clear the Lordship.
Please.
Item number 2.
Item 2, yes.
Yes, may I please, Sir Lordship, writ petitions, Sir Lordship, is arise, yes, Lordship. Lordship.
What do you want?
This writ petition is arise out of the impugn order that was passed by the Secretary Land Management on 21st for 2026, this year's.
He
And,
has been granted.
yes, sir, yes, Sir Lordship. Reversing the orders of Deputy Commissioner, which was passed on 25/2025. I will just want to check your Lordship to the revision orders passed by the Land Management Department, that is.
When was it allotted to you?
Your
The
Lordship.
land allotted to you?
Yeah, no, this is the, I'm, your Lordship, is the chairman of that is one Jalang village is here in ICR region. So I just want to take to your Lordship to the order passed by the Deputy Commissioner yourself.
But the order of the Deputy Commissioner has been stayed. No final orders have been passed as yet.
State by the,
Stayed.
yeah, state by the,
And so you can pursue with the secretary to pass final orders. Stay is only a temporary measure.
so we have submitted your Lordship to,
Mr. Ratan,
we have made twice also.
final orders have not been
No.
passed. See, interfering at this stage will not be any fruit, will not have any, will not be desired.
Direction may be given, your Lordship.
Of the matter, you can
Only
decide.
expedite matter.
Matters. We have already submitted on 20 of April also, we have submitted representations to the Secretary Law. Without hearing us, they have stayed the orders of reversed orders.
This order was passed on 21/4/2026.
Yes.
What is the next date?
Next date, they have not given the Lordship. We have already,
To see that order, 21/4/2026.
yes, Lordship. And interesting in this
Page.
case, yes, Lordship, it's order passed by, is on,
Impugned order.
yes, it's impugn orders is page 169, your Lordship. And another cases that, yeah,
169.
it's 169, your Lordship.
What is there?
Last, we can go through the last part, your Lordship.
Revision is maintainable, Mr. Ratan.
My lord, in fact, appeal, it should have been appeal.
That is it. He has attempted a revision.
Yes, my lord. In fact, under the,
Have you filed any application for modification of the interim order?
Interim orders, your Lordship, actually, we have also made representations to the Secretary Law Management.
Where is the representation?
It's reflect, I have given,
Please.
and yes, it's,
It is not right
Yes.
for the High Court to interfere at this moment.
yes, yes.
He is given an order of stay pending adjudication of the matter. without going into deep into the matter, how do you ask the stay to be vacated?
Your Lordship,
We can request the secretary to expedite the matter and pass final orders. And if you are aggrieved, you can come to the court if it
Yes, Lordship.
also allows you to come.
this can be done, Lordship, but one thing,
At this stage, there's hardly any scope of,
Yes,
we don't
my
even know what is the case about, what are the
Yeah.
intricacies. We can request, but the next date is not there.
Yes, my lord. Only direction is given that the
on 20,
verify and assess and identify the area.
If you come to 170, the last paragraph, with these observations, the revision petition is hereby admitted
Yes.
and is further directed this is to verify, assess, so and so.
Identify the so and so.
So passing an order of stay is only a consequential thing because to
Yes.
facilitate
Yes,
the
ultimately,
the directions to be complied with.
yes.
Why are you agreeing with this?
so Your Lordship, kindly see the page 24, 163, 65, Your Lordship. On 20
Difficult to interfere. We'll say that you will be at liberty to challenge final orders, and in the meantime, we'll request the officer to expedite the process. Okay?
that can be,
Yes.
that can,
Ms. K. N. Maling,
yes.
Learned Legal Aid Council. Also heard Sri N. Ratan, Learned AEG, Arunachal Pradesh. Para. Considering the subject matter involved, the instant petition is taken up for disposal at the motion stage. Para. The challenge in this petition is against an order dated 21/4/2026 passed by the Secretary, Department of Land Management. Full stop. By the efforts, it has been the Learned Legal Aid Council has contended that by the aforesaid order, by the impugned order, the earlier reasoned order dated 25/2025 passed by the Deputy Commissioner, Itanagar Capital Region, has been stayed without any notice.
Notice.
On the other hand, Sri Ratan, the Learned AG, has submitted that such interim order was passed only to facilitate compliance of certain directions which were passed while admitting the revision petition. A bare perusal of the impugned order dated 21/4/2026 would show that the grievance raised in the present writ petition is on the aspect of a stay on the order dated 25/5/2025 passed by the Deputy Commissioner, Itanagar Capital Complex until further order. Full stop. The said order dated 21/4/2026, however, appears to have been passed in the revision petition 1 of 2025, by which the revision was admitted and certain directions have been passed to the Deputy Commissioner, Itanagar Capital Complex, to verify, assess, and identify the land which was re-allotted to the police department with proper demarcation, along with geo-coordinate map in presence of the stakeholders. For ready reference, the relevant observations made in the order dated 21/4/2026 are extracted herein below, page 170. Page 170, pink color, last para. This court is of the view that the consequential direction to stay the earlier order of the Deputy Commissioner dated 25/5/2025 would be necessary to facilitate the earlier the directions which have been extracted above. Full stop. This court is also of the view that such measure is temporary in nature and for which there may not be any tangible grounds to institute the present challenge. Full stop. The petitioners, it is a different matter if such challenge was instituted against a final order passed by the commissioner, land management. Para, in view of the above, the instant writ petition.
Your Lordship, I just want to reflect one thing in this case, Lordship. On 25/2025, the Deputy Commissioner, I just faced 153, Lordship. I just want to go through page number 152 and 53. Just want to highlight it because that the lane that have demarcated in the identified by the revision petition by the land department is against the order passed by the Deputy Commissioner. I just want to highlight it because that's very important.
That Deputy
Yes.
Commissioner order is the subject matter of challenge.
Yes.
The commissioner will decide on that. We'll give you liberty. Last night, what was it?
And this must be clear, Lordship.
No. While the Learned Legal Aid Council has emphasized that the order dated 25/5/2025 has been passed by the Deputy Commissioner after taking into consideration all the
Circumstances of the
and is
petitioner.
justified, it is not in dispute that there is a scope to challenge such orders which has been done in the proceeding before the secretary to the government of Arunachal Pradesh land management. Full stop. Para. In view of the aforesaid position, this court is of the opinion that no relief whatsoever can be granted at this stage to the petitioner. Full stop. It is, however, directed that the proceeding be completed expeditiously by giving the petitioners an adequate opportunity of hearing. Full stop. It is also observed that the petitioners would be at liberty to challenge any final orders if so advised.
And status quos need to be maintained, Your Lordship, still.
That we cannot.
Unless.
Item number 3.
May Lordship, this is with regard to Lordship, land allotment matter, Lordship. I have applied the land allotment for my land allotment law. Application is pending before the Deputy Commissioner concerned, Lordship. Accordingly, before the previous Deputy Commissioner, Lordship, this kindly see the page number, Annexure 1 series, page number 22. DLR ratio, SK and the Deputy Commissioner has already recommended my case, Lordship. For
thereafter, what is your grievance?
Then, Lordship, what had happened? As per the purportedly this planning, this urban affairs, as per the report, page number.
But will it be a reason that only because your application is pending, you cannot be issued an eviction order?
Lordship, that is not the way. Yeah, there should be a propriety, Lordship.
Anyone can say that I have an application pending, so you do not evict me. There cannot be the only reason.
Lordship.
You have to cite some good reasons.
Yes, that is one of the reasons, Lordship. And another reason is, Lordship, I have already obtained NOC from the town planning, from the urban department, Lordship.
How much
for
area? How much area?
Area is very little area, Lordship, 235 square meter.
235 is not very little.
300, more than 300. It's in the report itself.
323. Yeah, 323 square meter. Yes, 323. Small area.
Not small. Where?
The colony is Agam colony, Lordship.
Which district?
Pasigat, Lordship. Page number.
Pasigat.
Pasigat is
land is
Isian
very valuable at Pasigat.
Kindly see page number 21, Lordship.
Yes,
This is
Madam Ate, what do you say?
Lordship, if your Lordship see the eviction notice, Lordship, he has been given
notice earlier also, Lordship. Saksi project is
Why did you
going
show
to,
cause to the eviction notice? Have you shown cause?
Lordship, I am told that
so
yeah,
cause notice
government
is
is,
given, Lordship.
government is,
Given,
Uh,
has he given his reply?
Lordship, no,
yes,
two times.
already order has been passed. Kindly see the page number 37, Lordship.
So you
Ground has been written, Lordship.
you have an avenue to appeal.
Yes, I
Lordship.
have filed.
Twice, Lordship.
Kindly see page number 39, Lordship. I have filed appeal, Lordship.
Where?
That
Page number
letter
39,
after this, Lordship.
annexure 7. I have filed appeal.
See, never
At this
so close.
stage, I am frank, matter may be shortened, Lordship.
Appeal before lies before whom?
Appeal before the deputy commissioner, Lord. This is the statutory appeal, Lordship. So, direction may
When
be
did you
passed
file the appeal?
on 25, Lordship, 25 May.
25 May.
Yes.
Yes, madam,
For
appeal lies
appropriate
before the
consideration,
deputy
Lordship.
commissioner.
This
Madam
can,
Ache,
this can
Yes.
decide.
appeal lies before the deputy commissioner.
Yes, Lordship.
So this can be decided by the deputy commissioner.
Yes,
Yes, Lordship, today is on second only, he has submitted on 25th.
Oh, okay, 25.
25th. Today is second only, then Saturday, Sunday was there.
Then we can
And
dispose this off.
There
Without
were one call.
Disposal of
With
the
the
appeal.
direction to Lordship, dispose
Do
the
not
matter.
carry out.
Yes.
Have you prayed for an interim order before the deputy commissioner?
Yes,
Where
kindly see page number 40, Lordship, in the last paragraph, second last paragraph. Requests your authority to consider my pending application aforesaid for regulation of my occupied land. In the meantime, set aside the eviction.
And that can,
That is there, Lordship.
you have not asked for a stay.
Not,
You filed an
that may be,
application.
that may be,
yes.
You file an application. which
Yes,
grant you-
appropriate
will
application,
give you some protection.
yes, appropriate application before the deputy commissioner.
Where is the eviction order?
Kindly see, this is page number 37 and annexure 6.
Is the eviction order?
Yes, eviction order.
Heard 3T Tapak Learned Counsel for the petitioner. Also heard Ms. G.A.T. Learned Additional Senior Advocate Arunachal Pradesh.
Yes, Lordship, this may be noted that, Lordship, in the earlier so-called notices also, she was asked not to build any further construction. She is
I'm not,
constructing, Lordship.
status quo may be maintained, Lordship. No further construction.
Considering the subject matter and as agreed to by the learned counsel for the parties, the instant writ petition is taken up for disposal at the motion stage. Full stop. Para. The petitioner has put to challenge an eviction order dated 6/5/2026 passed by the
Deputy Commissioner passed.
Assistant Commissioner,
Yes,
State Officer,
assistant, yes, assistant.
East Siang District. Full stop. By the said eviction order, the petitioner has been directed to vacate the government land of public premises situated at Agam Colony, Pasighat, within 15 days from the date of service of the order. Para. 3. Tapak, the learned counsel for the petitioner, has, amongst others, contended that after obtaining no objection certificate from the concerned municipal authorities, he is in she is in occupation, the petitioner is in occupation of the land and had applied for grant of LPC.
Land allotment.
Land
Land
allotment.
Land
This is
allotment.
Government land,
Government
Lordship.
land.
Land allotment, which is still pending, full stop. Under those circumstances, passing of the impugned eviction order is unreasonable, full stop. On the other hand, Ms. Sate, the Learned State Council has submitted that even on earlier occasions, there has been notices, there has been notices to vacate the government land, and in spite of that, the petitioner had carried on construction, full stop. She has also submitted that against the impugned order dated 6/5/2026, there is a scope to prefer an appeal. Full stop. She has also highlighted that though an appeal has been stated to be preferred, the same was done only on 25/5/2026 and immediately thereafter, on 2/6/2026, the instant writ petition has been filed. Para. Sri Tapak, the learned counsel for the petitioner, has submitted that he has apprehension that forceful eviction may take place as the appeal has not been taken into consideration as yet. Para. After considering the facts and circumstances and upon hearing the learned counsel for the parties, this court is of the considered opinion that instead of going into the inter se marriage of either of the parties, the appeal which has been preferred on 25/5/2026 be directed to be considered and disposed of expeditiously, which is footstop according to this. The Deputy Commissioner, East Siam District is accordingly directed to take on record the appeal filed on 25/5/2026 by the petitioner and pass appropriate orders in accordance with law and by hearing all and by giving the opportunity to all the stakeholders. The petitioner would also be at liberty to file an application for stay of the order of the state officer, and if the same is done within a period of a week from today, the eviction order shall not be given effect till such application is considered and disposed of. Full stop. The writ petition accordingly stands disposed of. Full stop.
Lordship, if application, they may not file the
If they
application
not
for a
file,
long
it's
time.
only if it is filed. That's only if it is filed.
Within
Within 1 week.
within a week's time. Yes, Lordship.
They have not given much time.
Yes, Lordship.
Item number 4.
Right, please, Lordship. Lordship, here, my 3-month salary has not been released by the authority, without any authority.
What do you do?
Lordship, I'm serving as executive engineer.
Why haven't you released the salary?
In this regard, Your Lordship, notice may be issued, Your Lordship.
Notice will issue, but why haven't you released the salary, madam?
Lordship, I received my last salary on May 2025.
People are not required to approach the High Court for salaries.
Your Lordship.
If this is the state,
Then I
What
need to get instruction, Your Lordship. Why the salary has not been
You're
released?
new officer,
No, Lordship.
then
It's been 38 years I am serving in the department, Lord.
old officer.
Yes, old officer.
Therefore you are ignored.
Yes, Lordship. Lordship, I have received
When are
my,
you retiring? 38 years you have served.
no, Lordship, 28.
28.
Yes, Lordship.
What is your age?
Age, Lordship, 3 years left in my job, Lordship.
Maybe only to acclimatize you.
Now 50
Acclimatize you, and then after the job you will be with less money.
Lordship, now
You
I'm,
get yourself acclimatized so that you can lead a normal life.
Lordship, I am 57 years now, Lordship.
Yes, madam. You take instructions.
Yes,
Monday-
Your
Monday.
Lordship.
We'll
Your
not,
Lordship.
keep this matter pending. Third, Sri K. Lolen, learned counsel for the petitioner, whose grievance is towards non-receipt of monthly salaries for 3 months.
Yes.
Full stop. In this regard, the petitioner has also submitted representations which have not been acted upon. It is submitted that the petitioner is presently serving as executive engineer within bracket auto, within bracket officiating in the Department of Transport. Para. Ms. Pangu, the learned state counsel, prays for some time to obtain the instructions. Para. In view of the above, list this case for motion hearing on next Wednesday.
Okay, Your Lordship.
Next Wednesday. Para, to facilitate the learned state counsel to obtain the instructions, that an extra copy of the repetition be furnished to her during the course of the day.
Lordship.
Obelisk, Your Lordship.
Deeply obliged.
Item number 5.
Para pendency of this petition shall not be a bar for redressal of the grievance of the petitioner. Item number
5.
5.
My lord, petitioners is MTS employee, my lord.
Empty.
Yes, she has been appointed, my lord, is MTS, my lord.
What
By
is the
that,
grievance?
my lord, I have been terminated from the service, my lord. That is my grievances, my lord.
Terminated because of what?
My lord, only allegation is for force and provocations.
Huh?
Without departmental inquiry, I have been alleged that force and fabricated appointment, so I have been terminated.
Force department.
Force, fake, it's not been appointed through competent authority. That has been appointed by one retired director, against which mass appointment, illegal appointments, the fake appointments has been issued, and against which around 12 district various cases has been registered against him now, my lord. Now, this is the one of that beneficiary, my lord. And has been
Let us know. Let us issue.
my lord.
What is your name?
My lord, Odgo. My lord, he has been, yes. Criminal case, I have, DDSC of Hinkyong has been directed to file an FIR against me, my lord, by Deputy Commissioner, my lord. On that part, my lord, stay may be given.
Why should we stay a criminal proceeding?
Yes, my lord.
Is there any, what powers do we have?
My lord,
If you are innocent, you
Yeah.
declare innocent.
my lord, in two instances, my lord,
See, prima facie, you are a beneficiary of some illegal action.
yes, my lord.
You are putting that to challenge.
Yeah.
We'll adjudicate it. You may be right in contending that you are not the beneficiary. But since there is a prima facie material, there are prima facie materials. Do you want to institute a criminal case? Can we ask them not to institute? Difficult. Third, Sri O. Dugan, learned counsel for the petitioner, who is aggrieved by an order dated 13/4/2026, whereby the petitioner, who was working as a multitasking staff with MTS in the government higher secondary school in Kyong, has been terminated from service.
Yes, my lord.
It is contended that such termination was not preceded by any departmental proceeding
Yes, my lord.
and has been done on the allegation that the appointment was a forced one.
Yes, sir.
Sri T. Tagum, learned standing counsel, Education Department, has however submitted that the petitioner is one of the beneficiaries in a large-scale illegality. Which was done by one of the retired
Director, Elementary Education, my lord.
retired director elementary education, and criminal cases are pending. Full stop. Para. Let notice be issued, returnable on on 30th, on the 1st of July. Is it okay? 1st of July, 2026. Sri Tagum, the learned standing counsel, accepts notice on behalf of all the respondents.
Madam.
Let extra copies during the course of the day.
Right.
Sri Dugong, the learned counsel, prays for an interim order to stay any initiation of criminal proceeding. Post of para. This court is, however, of the view that there cannot
My
be
lord,
an
my lord, they may not, this order, that may not be mentioned, my lord.
Diplomas.
Item number 6.
May I help? Well, I'm extremely sorry. My friend Mr. Jumga Karwar is appearing in this matter, but due to some medical urgency, he has to leave for the Guwahati unit. And moreover, I have been informed that the parties have arriving into settlement in this matter.
You take the instructions, we'll close this day after tomorrow.
Your Lordship,
20 matter, we are not adjourning. We're making it very clear. If there is some reasons which are genuine, like medical emergency, then we can accommodate for 1 or 2 days, get hold of another council.
at least on Monday, Your Lordship, Monday.
The day after tomorrow.
Your Lordship,
A prayer for adjournment has been made on behalf of the petitioner. However, considering that this matter is pending since the year 2020, while the prayer is declined, a short accommodation is made directing listing of this matter on 5th of June. Take instructions. If it's settled, make the instruction, make the submission, matter will be closed.
Yes, sir.
Item number 8.
May I please, Your Lordship, if my learned senior and additional AG agrees, there is something I would like to point out before my lord arguing the case.
Today,
It is for admission, Lordship.
admission, we admit it or what? Or it can be taken up for disposal.
If my lord if my lord will take up for disposal, that is why I was saying, I was anticipating that it may be taken up for disposal.
Normally we do.
Yes. So, Lordship,
We don't leave cases to be taken up tomorrow.
yes, Lordship, I'm aware. No, Lordship, I'm in a bit of two minds because, Lordship, so far as the merit of the case is concerned, I'm very confident that I have a very good case. They'll also agree. It is their own document. Anyways, Lordship, the case is of a sports quota, appointment under sports quota. Now there are office memorandums under which I'm eligible and the respondent number 5 is not eligible. But
You are 5, yes.
yes, there is a glitch, however, that after my candidature was rejected, I had applied for in another department in which I have
Been appointed.
got the job. Now that aspect also I have already mentioned in my petition. Now, day before yesterday, they filed this additional affidavit bringing this into record. If my lord is, if otherwise I succeed, if my lord is going to take that into account, then I'll also have to bring some documents because I know that she has also applied somewhere else.
Is somewhere else, why don't you let the private respondent try for this?
My lord, no, private response already appointed.
Appointed.
Yes.
So what are your grievances? There is no grievance.
My lord, in terms of the, in terms of the, no, not same department, my lord. There is a small job, my lord.
No, Group C post.
Group C post, but it is not as per my qualifications.
Today's context,
Yes.
getting a government job is almost a dream.
My lord.
You have got one.
My lord, but that is not my dream job, my lord.
Be secured. You're letting the job be secured.
In that case, my lord, I may be allowed to file a reply, my lord. Because I have documents, but it is this moment, my lord.
Heard Sri and Learned Council for the petition. I also heard Sri N. Ratan, Learned AG, Pustak. Sri D. Panging, Learned Senior Council. He is present for the respondent number
5.
5. Para. Ms. Dangan, the Learned Council has submitted that the respondent number 5 has filed an additional affidavit on 1/6/2026, bringing in some new facts, which she would like to respond by filing an affidavit. Full stop. Para. She accordingly pays for and is granted 2 weeks' time.
I'm applying for RTI, so therefore 3 weeks time, my lord.
For 3 weeks' time to file such affidavit. Para. You get more time. Don't say applies for some applies for reasonable time to file such reply, and has also contended that certain documents are sought for by invoking the RTI Act. Para. Considering the above, matter is adjourned to be listed on 22nd of July. 22nd of July, by which time the affidavit is required to be filed.
Oblige.
Item number 9.
Now, the short question arises in this arbitration petition. Question is whether there is an arbitration clause and parties are bound by it. The notice under section 8 was issued, and we have also intimated that we are suggesting the name of one of the arbitrator, and asked the respondent side to nominate or to express his opinion.
It is only for the purpose of appointment of an arbitrator. 11 petition.
11.
Yes, Mr. Jini.
Lordship, in fact, we are disputing that the clause they are referring to for arbitration, that clause does not speak anything about arbitration. Rather, it speaks about mediation, Lordship. This regarding arbitration, it's completely silent. That clause they are referring to.
Let's see
There is no agreement as such between the parties which talks about going for arbitration. Yes,
Let's see
Lordship.
that clause. Let's see that clause then.
Lordship, that is clause 5.
Page 18.
On 8.
Yes. Well, facts is like this. Let me just place the covering facts.
No, we are not on the merits, we are only on the appointment.
Yes. No, Malad, here,
Just show us the clause.
here kindly see, first I will invite your lordship to page 19.
Yes.
Definition subcontract definition part, that
One F.
definition.
One F.
Clause 1 is the definition. This is between me and the respondent.
What?
Subcontracts.
Clause F.
Subcontract means, lordship F. Subcontract means the agreement on the subcontractor by the contractor for the execution of the balance work in accordance with the specifications, drawings, terms and conditions, workmanship as per main contract requirement for satisfactory completion works. Completion of the main contract bearing number so and so, dated 31/3/17, shall be part and parcel of this agreement. This is there.
Where are you reading? Page 19.
Page 19.
Definition part.
Definition part.
Clause F.
Clause F.
Subcontract.
Definition subcontract. What is subcontract? What is it defined?
So we'll note it for a moment. I'll come back to the subcontract.
Yours is a subcontract.
I am a subcontract under the contract, main contract.
He is the main contractor.
He is the main contractor.
Lordship, yes, I am the main contractor. Yes, I am the main contractor.
So he has the main agreement with the department. It's a construction of road. Construction. So says this main contract has been referred to, and it says that the main contract bearing number so and so, that so and so shall be part and parcel of this agreement. Very specific, clear. And wherever not mentioned, subsequently, all the provisions in the contractor's scope, responsibility, risk and liability shall be binding on subcontractor. So, in definite words, they say that the main contract shall be part and parcel of this agreement also. Now kindly come to
page 21. Clause
page 21,
Clause 5.
2-1.
clause 5. 2-1. Clause 5. Dispute resolution and termination of contracts. That any disputes arising out of the contract shall be resolved mutually upon discussion. B. However, in case the disputes cannot be resolved mutually, further meetings and under aegis of Sri Tarun Nabam and Sri
Sanjeev Tandon.
This is also there. That the subcontractor is strictly instructed under this agreement that there should not be violation or against clauses. So A and B, 5A and B, this speaks about mediation and then to be tried by another two persons that all have failed. My responsible submission would be this also refers to go for kind of arbitration that you first try this and then kindly read the main contract now, because it is a part and parcel that forms a part of this. This has emanated from the main contract. And the main contract speaks about dispute resolution.
Arbitration clause.
Arbitration clause. That will be attracted in this contract also. That's my full submission. And that main contract your lordship will find in the additional affidavit. Lordship.
But that main contract being a part and parcel of this is only for the execution of the work, not for resolution of disputes.
Well,
for resolution of dispute, there is a specific clause 5. How
Clause
do you
5.
resolve a dispute? So far as the subcontract is concerned.
Yes.
That is by negotiations or within the ages of two persons.
Ages of two
But
persons.
if
So-
arbitration as such is not specified,
True.
you have to agree upon it. We cannot impose arbitration.
My full submission. Though they are term arbitration.
Let us see the main contract.
Yes, that is
which
main
page?
contract at page arbitration clause. Sorry, the additional affidavit lordship will take.
Page 57. 57.
Page 57.
57. This is main contract is between whom?
Between
The PWD and the contractor, my contractor, main contractor. Respond.
Page?
Page 57.
57 is your affidavit, I think.
Yes, additional
Now, where is the contract?
contract starts at page
Contract starts, I'm referring to that particular page, that starts at page
Annexure
35.
35.
35.
Yes.
Annexure 1.
Starts at page 35, and then the clause
57.
57.
Page?
57. 29. Clause 29.
Page 57.
Yes, no, the page 57, clause 29. Yes, 29. In the case of any disputes arising out of the meaning of any provisions under the agreement or specifications, etc., the case may be referred to a person of the rank of superintending engineer, the appointment of which is to be made by the secretary to the government or municipalities for arbitration under relevant law. This is for arbitration under relevant law. This speaks about the arbitration. Now, question is whether that can be read as a part of the subcontract and parties will be bound by that agreement. Law says that it is specific. So for the arbitration agreement is concerned, it is a separate agreement, but independent of the main agreement. That is what the law. Now, I will take your lordship to a recent judgment of the Apex Court, how they have interpreted it. In civil offense. This is 2026 SCC online 854. Hirani Developers.
Page 54.
Page 854.
854.
Yes.
226 SCC online 854.
2026 SCC online SC 854. Hirani Developers versus Nehru Nagar Samriddhi CHS Limited. Well, facts are relevant for our purpose. May I read short judgment? Not long. Leave granted. Pair 2. Existence of an arbitration agreement is in dispute. So that's how our dispute also is. By common order, dated 26/6/2025, the High Court of Judicature in Bombay held that there was no such arbitration agreement between the parties and dismissed the 5 applications filed under Section 11 of the Arbitration and Conciliation Act 1996 by the appellant Hirani Developers seeking appointment of an arbitrator. Hirani Developers, the appellant, a proprietary concern involved in a real estate business, entered into a development agreement on 2012-2011, registered as document number so-and-so on 4/7/2012, which Nehru Nagar Samriddhi Cooperative Housing Society Limited. Response number 1, for redevelopment of its project, which was in a dilapidated condition. The development agreement provided for a dispute resolution mechanism in clause 36, which reads as under. In case of any dispute or difference arose in respect of the terms and conditions of said agreement, both parties shall appoint sole arbitrator and said arbitration proceedings shall be conducted under the provisions of the Arbitration and Conciliation Act 1996. Long thereafter, the appellant entered into separate permanent alternate accommodation agreements with the society and its members. We are concerned with 5 such agreements that the appellant entered into with the society and its members, namely Narayan Haldankar, Malan, so-and-so, 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 these are the names, and so-and-so. The respondents herein. These agreements were executed on 2/9/2023 and 12/1/2024. All the agreements were on identical lines and each of them contained the very same clause 14 which reads as under. It is clarified that all the terms and conditions of the development agreement dated so-and-so shall be construed to form a part of these presents, and all the clauses of the same shall be binding on the parties hereto. That was the clause in the subcontract. It appears that the respondent members filed a complaint against the appellant under the Consumer Protection Act 2019. At this stage, the appellant got issued individual legal notices dated 28/2/25 to the 5 respondent members under Section 21 of the Arbitration Act, Clause 36 of the Development Agreement, and calling upon them to choose one of the arbitrators named therein. However, by reply dated 7/25, the respondent members stated that they had approached the Consumer Dispute Redressal Commission at Bandra and refused to proceed with the proposed arbitration. Thereupon, the appellant filed the subject application before the High Court under Section 11 of the Arbitration, seeking appointment of arbitrator. By the impugned common order, the High Court negated the plea of the appellant on the ground that the arbitration clause was contained in the development agreement that the appellant had with society, but there was no such arbitration clause in the permanent alternate accommodation agreements that the appellant had executed with each of the respondent members. The High Court opined that in terms of Section 7(5) of the Arbitration Act, mere reference to an earlier document in the later one would not be adequate to incorporate the arbitration clause from the former into the latter, as it would be necessary to demonstrate a firm commitment to go in for
So we have read this judgment.
Yes.
But the principal difference is that their parties were the same.
No,
Here,
not the same.
Here,
my lord, parties are not the same because this was first one with the society, second was the society and 7 individual members for whom permanent constructions were sought to be made. So the permanent members said, those members, they said, they disputed that there is no such agreement, there is no any arbitration clause between them. Then the reference was made that in the main contract there was one. And in the subcontract it was mentioned that it will form part and parcel, that first para that quoted. After para 5, they have noted this clause within quotation. That was the clause of agreement, reference to arbitration in the subcontract. We says that development agreement 4712 shall be construed to form a part of these presents, and all the clauses of the same shall be binding on the same parties. Now, referring to MR engineers, court has elaborated, quoting paragraph 16 from that judgment. So I'm reading that. Quotation I am reading first of all, 16. It is from the MR engineers. There is a difference between reference to another document in a contract and incorporation of another document in a contract by reference. In the first case, the parties intend to adopt only specific portions or part of the referred document for the purposes of the contract. In the second case, the parties intend to incorporate the referred document in entirety into the contract. Therefore, when there is a reference to a document in a contract, the court has to consider whether the reference to a document is with the intention of incorporating the contents of that document in entirety into the contract or with the intention of adopting or borrowing specific portions of the said document for application to the contract. Now, 17. We will give a few instances of incorporation and mere reference to explain the position, illustrative and not exhaustive. If a contract refers to a document and provides that the said document shall form part and parcel of the contract, or that all terms and conditions of the said document shall be read or treated as a part of the contract, or that the contract will be governed by the provisions of the said document, or that the terms and conditions of the said document shall be incorporated into the contract, the terms and conditions of the document in entirety will get bodily lifted and incorporated into the contract. That is my case now. When there is such incorporation of the terms and conditions of the contract, every term of such document, except to the extent it is inconsistent with any specific provisions in the contract, will apply to the contract. If the document so incorporated contains a provision for settlement of disputes by arbitration, the said arbitration clause also will apply to the contract. 18. On the other hand, where there is only a reference to a document in a contract in a particular context, the document will not get incorporated in entirety into the contract. For example, if a contract provides that the specifications of the suppliers will be as provided in an earlier contract or another purchase order, then it will be necessary to look to that document only for the limited purpose of ascertaining of specifications of the goods to be supplied. The referred document cannot be looked into for any other purpose, say price or payment of price. Similarly, if a contract between X and Y provides that the terms of payment to Y will be as in the contract between X and Z, then only the terms of payment from the contract between X and Z will be read as part of the contract between X and Y. The other terms, say relating to quality and delivery, cannot be looked into. Again, in NBCC, so and so, this court has held that an arbitration clause in another document would get incorporated into the later contract by reference if the contract contains a clear reference to the document containing the arbitration clause, and such reference to the other document clearly indicates the intention to incorporate the arbitration clause into the contract. And such arbitration clause is capable of application to the disputes under the contract and is not repugnant to any term of that contract. I pause here for a moment, my lord. Kindly see. They are in our in the subcontract agreement, which has been categorically said that this will form a part and parcel of this agreement. So it need not have to refer to specifically to the clauses as a whole. By a sole submission, the whole body of the agreement has been lifted and incorporated here by referring in that way in clear terms. Now, 11. Applying the aforesaid edict and in particular the illustration in paragraph 17 of MR Engineers and Contractors Private Limited, we find that this was not a case of mere reference to an earlier document containing an arbitration clause. The later permanent alternate accommodation agreement entered into by the appellant with the respondent members unequivocally recorded in clause 14 thereof that all the terms and conditions of the development agreement dated 4/7/2012 shall be construed to be form part of the said agreement, and all clauses of the same shall be binding on the parties to those later agreements. There could be no clearer indication of the intention of the parties to incorporate and assimilate the development agreement dated 4/7/12 in its entirety into the later permanent alternate accommodation agreement, not stopping short at asserting that all terms and conditions of the state development agreement should be assumed to be part of the permanent agreement. Clause 14 goes on to affirm that all clauses of the development agreement will be binding on the parties to permanent alternate accommodation agreement. So it says that here they have gone further, saying, in my case, reference was made to the extent that itself, the main contract bearing number so and so, dated so and so, shall form part and parcel of this agreement. Therefore, my respectful submission on this limited ground that this is a clear indication of the intention of the parties, that in case of anything, any dispute also, the arbitration clause will come in, entire clauses will be operative, and there is no room otherwise for him to say now that there was no arbitration clause. Because the parties have intentionally, knowing fully well, put this particular clause there, categorically mentioning and asserting that the agreement, the original agreement, which is the basis of this subcontract agreement, shall form a part and parcel of this agreement. Therefore, nothing more is required to be said. It is a clear and categorical indication. That's enough in my respectful submission to constitute. Therefore, my respectful submission is here is a case for appointment of arbitrator. I heavily rely on this. Lordship has seen it. Even the explanations given by their lordships, explaining under what situation this will be constituted to be bodily lifted and incorporated, is very, very illuminating, and clearly it has indicated the minds of the court. Therefore, it leaves no scope otherwise to think that this reference would not amount to referring adequately or lifting the entire body of the agreement, main agreement, making a part and parcel of this agreement. That's my submission.
Yes, yes.
Regarding this, in the subcontract agreement, Lordship, which they are referring to, Lordship, clause 5.
Page 21.
Page 21. Lordship has correctly pointed out that there is already a clause in regards to dispute resolution, Lordship. Initially, when they filed this writ petition, Lordship,
Not writ petition.
arbitration petition, sorry, Lordship, arbitration petition, when it was filed, Lordship, they were harping on this particular clause, Lordship. Now, when we filed our reply, then in the additional affidavit, they came up with the contention that they are raising right now, Lordship.
Can I see the prayer?
Arbitration petition. Paragraph 10 of their petition, Lordship, page 8.
10.
10. That it is respectfully submitted that since a dispute had arisen between the parties, where arbitration being one of the means of dispute resolution, the petitioner by notice dated so and so invoked clause 5 of the subcontract agreement and appointed Honorable Justice retired R.C. Sarma sole arbitrator for resolving the dispute in terms of the said clause and reference the following claims for arbitrations. They were trying to invoke this clause 5. Lordship has seen the clause 5, Lordship. Clause 5 does not whisper anything about the arbitration. The Lordship is aware about that engineering, MR engineering case, Lordship. And so many decided cases, Lordship. When there is a contractual agreement, the arbitration clause has to be very specific and very clear. Correct, correct.
Paragraph?
Lordship, paragraph 24 is the relevant, Lordship. Now here, Lordship, after filing of our affidavit in opposition, Lordship, reply, Lordship, in their additional affidavit, they have brought out this particular clause of the subcontract agreement 1F. Lordship may kindly come to that, Lordship, before taking reference of this particular judgment, Lordship. I'll just page 19 of the petition, Lordship, main petition.
Yes.
Lordship, they have not completely read what is the content of that particular clause of the subcontract agreement, Lordship. It reads, Lordship, the main contract bearing so and so shall be part and parcel of this agreement, and wherever not mentioned, subsequently, all provisions in contractor's scope, responsibility, risks, and liability shall be binding on subcontractor. Now, those all clauses that has been mentioned, it's regarding to construction of the road, Lordship. It doesn't talk about the arbitration clause, Lordship. Now, when we talk about arbitration clause, Lordship had seen the clause 5. It's here the dispute resolutions clause is very much mentioned in this particular subcontractual agreement, Lordship. Now, when this dispute resolution clause is very much mentioned in the subcontractual agreement, now at this stage, can they harp on the main contractual agreement wherein they are not part of that agreement, Lordship? It's a subcontractual agreement, Lordship. Now here it's clearly mentioned about the dispute resolutions mechanism, Lordship. Now in this dispute resolution mechanism, it's the clauses that has been mentioned. There is no whisper of arbitration clause, Lordship. Now comes, Lordship, since they are harping on section 7 subclause 5 of the Arbitration and Conciliation Act, taking reference of the main contractual agreement, Lordship. So this MR engineering judgment will be required. Lordship, those principle has been laid down, Lordship. In what conditions and what principles subsection clause 7 subclause 5 can be invoked, Lordship. Paragraph 24 is the relevant paragraph. These conditions are to be fulfilled, Lordship. Those conditions are not fulfilled in this present scenario, in this case, Lordship, in this instant case, Lordship. My contention is the scope and intent of section 7, subclause 5 of the Act may be therefore be summarized this paragraph 24, Lordship.
Yes, please.
The scope and intent of section 7, subclause 5 of the Act therefore may be summarized this. An arbitration clause in another document would get incorporated into a contract by a reference if the following conditions are fulfilled. These are all the conditions that has to be fulfilled. The contract should contain a clear reference to the documents containing arbitration clause. Lordship, whether that there is a reference, Lordship may kindly come back. Lordship will just try to come back to that particular clause, Lordship, of the main petition, Lordship, which they are referring to 1F, Lordship. Page number 19, Lordship.
Yes.
Lordship, I have read it out, Lordship. There is no whisper of arbitration clause here, Lordship. This condition number 1 goes, Lordship. The contract should contain a clear reference to the documents containing arbitration clause. Nothing as such in this, Lordship, particular clause which they are referring to, Lordship, where they are trying to bring in the main contractual agreement into this subcontractual.
That should not be the meaning. See, the contract, let us read 24. Scope and intent of 7.5 may therefore be summarized as follows. An arbitration clause in another document would get incorporated into a contract by reference if the following conditions are fulfilled. The contract should have a clear reference to the documents containing the arbitration clause. There is a clear reference to the main contract in which indeed there is an arbitration clause.
Of course, Lordship, there is.
So one is fulfilled. One is fulfilled. Here, reference is not to the arbitration clause, reference to the is to the document which should contain a clear arbitration clause.
Lordship, then we come to the second conditions, Lordship. The reference to the other documents should clearly indicate an intention to incorporate the arbitration clause into the contract.
Yes, that you can
Lordship.
submit, open for
Lordship, that,
submission, because here the intention of the parties gets into paper, into documented by incorporation of this particular clause at page 21, namely the dispute resolution mechanism.
Correct.
You have a separate dispute resolution
mechanism.
That you can expand your argument.
Correct, Lordship. That and clause 3, Lordship. The arbitration clause should be appropriate, that is capable of application in respect of the dispute under the contract and should not be repugnant to any terms of the contract. Now, Lordship, referring to subclause 29 of the main contractual agreement, Lordship, this particular clause, can it be incorporated in our subcontractual agreement? That whether it would be applicable, Lordship?
29,
page 57 of their additional affidavit, Lordship.
57.
Lordship. In case of any dispute arising out of the meaning of any provisions under this agreement or specifications, etc., the case may be referred to a person on rank of superintendent engineer, the appointment of which is to be made by the Secretary PWD Government of Arunachal Pradesh for arbitration under relevant law. Now, this is not possible to be incorporated in the subcontractual agreement, Lordship. This is not at all possible. Lordship, sub clause 3 also goes, Lordship, that way. Lordship, the arbitration clause should be appropriate, Lordship. This is not appropriate at all in our case, Lordship, since it's a subcontractual agreement, Lordship. I am nothing to do with the department, Lordship. The petitioner is not nothing to do with the department. I'm the one who has. I'm answerable to the department. He's not answerable, Lordship. It's a private party agreement between the parties, Lordship. Lordship, that so why, Lordship, this. I'm saying that, Lordship, this particular clause which they are trying to bring in the subcontractual agreement, that cannot be appropriately applied, Lordship.
Yes.
As a further, when the parties entered into a contract making a general reference to another contract, such general reference would not have the effect of incorporating the arbitration clause from the referred document into the contract between the parties. The arbitration clause from another contract can be incorporated in the contractor where such reference is made only by a specific reference to the arbitration clause. Where a contract between the parties provides that the execution or performance of that contract shall be in terms of another contract, which contains the terms and conditions relating to the performance and provisions for settlement of disputes by arbitrations, then the terms of the referred contract in the execution performance alone will apply and not the arbitration agreement in the referred contract, unless there is a special reference to the arbitration clause also. Where the contract provides that the standard forms of terms and conditions of an independent trade or professional institution, as for example, the standard terms and condition of trade association or architect, will be bind them or apply to the contract. Such standard form of terms and conditions, including any provisions for arbitration in such standard terms and conditions, shall be deemed to be incorporated by the reference. Sometimes the contract may also say that the parties are familiar with those terms and conditions, or that the parties have read and understood the said terms and conditions. Where the contract between the parties stipulates that the condition of contract of one of the parties to the contract shall form part of their contract, for example, the general condition of contract of government where the government is a party, the arbitration clause forming part of such contractual will apply to the contract between the parties. Lordship, here the three conditions that has to be seen, Lordship. Lordship, only one condition, apart from that, Lordship, two conditions are not fulfilled. So, Lordship, they cannot take harp on this particular provision and say that, Lordship, that arbitration clause applies on them, Lordship. Lordship, I'll just like to rely on one more judgment, Lordship. NBCC India Limited versus Jillion Infra Project Private Limited, Lordship. 28, 29, 30.
Paragraph?
Paragraph, Lordship, last second paragraph, page, Lordship, last third page, Lordship. Paragraph 28, 29, and 30 is the relevant paragraph. It is thus clear that the intention between the parties is very clear. Clause 7.0 of LOI, which also forms part of the agreement.
You're reading paragraph 28.
28, Lordship. Specifically provides that the redressal of the dispute between the NBCC and the respondent shall only be through civil, Lordship. In our case, Lordship, the clause, arbitration clause, Lordship, in the subcontractual agreement
Not arbitration, dispute resolution.
Dispute resolution, Lordship. Dispute resolution, correct, Lordship. Clause 5, A and B, Lordship. It talks about, Lordship, try to mutually settle, and then if not, Lordship, by two persons, namely Tarin Nabam and Sanjay Thana, Lordship. As already discussed here in above, when there is a reference in the second contract to terms and conditions of first contract, the arbitration clause would not ipso facto be applicable to the second contract unless there is a specific mention reference thereto. Lordship, one app, Lordship, I have shown, Lordship. It does not specifically talks about the arbitration clause, Lordship. That apart, Lordship, clause 5, already it's there, Lordship. Dispute resolutions mechanism is already there, Lordship. Clause 30, Lordship, we are of the considered view that the present case is not a case of incorporation, but the case of reference. As such, a general reference would not have the effect of incorporating the arbitration clause. In any case, clause 7 of LOI, which is also a part of the agreement, makes it amply clear that the redressal of dispute between NBCC and the respondent has to be only through civil courts having jurisdiction of Delhi alone, Lordship. Here also, Lordship, the main subcontractual agreement, Lordship, dispute resolutions, it talks about not the arbitration, but can be settled through mediation, in fact, Lordship. That is the clause that is mentioned here, Lordship. Now, so while, Lordship, since the mediation has failed, Lordship, in fact, we have approached the civil court, Lordship. We have instituted a civil money suit against the petition applicant here in Lordship. Lordship, that
Number?
money suit number 57 or 25, Lordship, which is pending before Civil Judge Senior Division UPR, Lordship. So what my humble submission is, Lordship, this is a pit case where the dispute between the parties can be resolved through other mechanism, not through arbitration, Lordship. We have already instituted a civil case against the money suit against the.
Where did you file?
After filing of this. And that has been put on hold because of the pendency of this.
Yes. That order, Lordship, I have annexed in my reply, Lordship, page number 87, Lordship. They are in fact participating in that money suit also, Lordship. They have entered their appearance, Lordship. Or judgment. So, Elite Engineering. Then Lordship, here in Elite Engineering and Constructions Private Limited, Lordship, This case taking reference of MR Engineering and Contractors, Lordship, which the clause which I have referred, Lordship. Relying on that particular paragraph, the case was decided, Lordship. Relevant paragraph is 14, 15, 16, 17, and 18, Lordship.
Yes.
Lordship, one more judgment I would like to rely, Lordship. Mahanadi Coalfields Limited and others, Lordship. This is of 2022, Lordship.
What proposition?
Lordship, Lordship, it talks about the absence of arbitration agreement, Lordship.
Paragraph?
8, 9, and 18, Lordship. Paragraph 8. Paragraph 8, Lordship. They have taken reference of Jagdish Chandra and Ramesh Chandra, Lordship, two judge bench decision. This court, while relying upon the earlier decision, so and so, enumerated the principle governing what constitutes an arbitration agreement. R.B. Ravindran J. Justice, speaking on behalf of the bench, held that the word used in an arbitration agreement should disclose a determinations and obligation on behalf of the parties to refer disputes to arbitration, Lordship. This court injures the intention of the parties to enter into an arbitration agreement shall have to be gathered from the terms of the agreement. If the terms of the government agreement clearly indicate an intention on the part of the agreement to refer their dispute to a private tribunal for adjudication and willingness to be bound by the decision of such on it is an arbitration agreement. Well, there is no specific form on arbitration. The word used should disclose determination and obligation to go to arbitration and not merely contemplate the possibility of going for arbitration, where there is merely a possibility of the parties agreeing to arbitration in future as contrasted from an obligation to refer dispute. There is no valid and binding arbitration agreement. Even if the words arbitration and arbitrary tribunal are not used with the reference to the process of settlement or with reference to the private tribunal which has to adjudicate upon the disputes in clauses relating to settlement of dispute, it does not distract from the clause being an arbitration. If it has the attributes of elements of arbitration, they are agreements should be in writing. The parties should be agreed to report any dispute present or future between them to the decision of a private tribunal. The private tribunal should be empowered to adjudicate upon the dispute in an impartial manner, giving due opportunity to parties to put forth their case before it. The parties should have agreed that the decision of the private tribunal in respect of the dispute would be binding on them. Well, where the clause provides that in event of disputes arising between the parties, disputes shall be referred to the arbitration. It is an arbitration agreement where there is a specific and distinct expression of intent to have the dispute settled by arbitration. It is not necessary to set out the arbitration to make it an arbitration agreement, but where the clause relating to the settlement of disputes contains words which specifically exclude any of the attributes on arbitration agreement or contains anything that distracts from arbitration agreement, it would not be an arbitration agreement. For example, where an agreement requires and permit an authority to decide and claim or dispute without hearing or requires the authority to act in that interest of only one of the parties, or provides that the decision of the authority will not be final and binding on the parties, or that if the either party is not satisfied with the decision of the authority, he may file a civil suit seeking relief. It cannot be termed as arbitration agreement. Lordship, here clause 29, which they are trying to bring in the subcontractual agreement, Lordship, 29, Lordship, whether it is possible in the present case, not at all, Lordship, as per this ruling, Lordship. But mere use of arbitration or arbitrator in a clause will not make it an arbitration agreement. Now, this agreement which they are trying to bring in the subcontractual agreement, Lordship has to see that whether it is feasible for both the party in the present case to go for arbitration, Lordship. If it requires, contemplates, or further or press consent of the parties for reference to arbitration, for a use of words such as parties can, if they so desire. Lordship, this also, Lordship, in this particular clause of 29, Lordship, the word used is maybe, Lordship. It's not shall, Lordship. For example, use of words such as parties can, if so desire, refer the dispute to, or in the event of any dispute, the parties may also agree to refer the same to arbitration, or if any dispute arises between the, they should consider settlement by arbitration. In clause relating to settlement of dispute indicates the clause is not intended to be an arbitration agreement. Similarly, a clause which states that if the parties so decide, the dispute shall be referred to, or disputes between the party, if so agree, shall be referred to arbitration, is not an arbitration agreement, Lordship. Now, as per this ruling, Lordship, the clause 29 cannot be termed as an arbitration agreement, Lordship, since there is a use of may, Lordship. There is no word shall, Lordship. Now, in that scenario, Lordship, whether can we bring this particular clause in the subcontractual agreement and go for arbitration clause, Lordship? In my considered opinion, Lordship, cannot, Lordship. Such clause merely indicates a desire or hope to have the dispute settled by arbitration, or tentative arrangement to explore arbitration as a mode of settlement, if and when a dispute arises. Such clauses require the parties to arrive at a further agreement to go to arbitration and when the dispute arises. Lordship, so while, Lordship, this particular clause is may, Lordship, may word has been used. In the main subcontractual agreement, the subcontractual agreement, Lordship, clause 5, is very much silent about the arbitration, Lordship. It only talks about mediation, Lordship, in my considered opinion, Lordship. So while, Lordship, they cannot bring in this clause 29 here and say that the arbitration clause will be applicable in the present case, Lordship. Such clauses require the parties to arrive at a further agreement to go to arbitration and when the dispute arises. Any agreement or clause in an agreement require or contemplating a further consent or consensus before a reference to the arbitration is not arbitration but an agreement to enter into an agreement in future, Lordship. Now, the future agreement that they have entered, Lordship, I am reiterating again and again, Lordship. This talks about the mediation, Lordship. There in the subcontractual agreement, if that the intention was to go for arbitration, then it would have been clearly being indicated in this particular clause of 5, Lordship. That is missing, Lordship. In the present case, clause 15 of the country's is titled settlement of dispute. However, the substantive part of the provision makes it abundantly clear that, because paragraph 9, Lordship, that there is no arbitration agreement between the parties agreeing to refer either present or future dispute to arbitration. So, Lordship, this particular clause paragraph, it's very much applicable in our case also, Lordship. The argument that I am putting across, Lordship. Relevant paragraph 18. For the above reasons, we have come to the conclusion that the invocation of the jurisdiction of the High Court under section 11 subclause 6 of the 1996 Act was not valid, and there being no arbitration agreement between the applicants and the respondent, no reference to arbitration could have been made. We accordingly allowed the appeal and set aside the impugned judgment and order of the High Court dated so and so so and so. Respondent would, however, be at liberty to seek recourse to the remedy available in law to pursue the redressal of grievances, Lordship. Since I have been contending, Lordship, money suit has already been filed, Lordship. The dispute between the parties, his lordship, that I have sublet the work to him, lordship, for execution of certain portion of the road, lordship. While he was executing, he left the work in the midway, lordship, without completing the work, lordship. So that is the whole dispute in the case. Now they say that they say that we have completed the work, so bill has to be paid to him, lordship. Now we are saying that you have incompleted the work. You have not completed the work, lordship.
Okay.
So whole dispute is before the civil court, lordship.
If I will be required, can do it right now. Or it was- 2-3 minutes.
2 minutes, yes.
Just before we rise, we can complete this matter.
Firstly, on
But but only maximum 5 minutes.
Yeah. On facts, suit has been filed by them. After filing of this petition, under this arbitration petition, we appeared and raised objections that in view of the arbitration clause, this suit doesn't lie, it cannot proceed. And our application is also pending for arbitration, for matter of arbitrator. Therefore,
You have filed section 8 also, invoke section 8 also.
Yes.
In the suit.
Yes. Stop. Therefore, this is one point. Secondly, my lord, Lordship has seen that latest in the Hirani developers case, the MR engineers and the CC have been very clearly discussed, and thereupon the court has held what I have already placed. I won't repeat it. Now, clause 5 of the subcontractor.
Yes.
Clause 5 of the subcontractor agreement, whether I'm asking myself whether it bars arbitration as such. There is nothing, no word to show that they will not go for arbitration. Rather, my respectful submission would be, here lies the genesis of arbitration. Well, mediation is a part of arbitration. Ultimately, it will go for arbitration, that we are not going to court, we are trying ourselves through some mediators. And court should be avoided. That was the intention.
The main contract.
Main contract has the clause of arbitration, so there is no specifically to be necessity to mention. Even if not mentioned, it will not come in a way that you cannot invoke it. And secondly, my lord, I ask myself, second clause it says, however, in case of any dispute cannot be resolved mutually, further meetings under aegis of so and so, so and so. These two arbitrators I will submit that this is indirectly two arbitrators has been chosen, they will arbitrate between us and find out. They also fail. Then ultimately what is the, well, it does not, in my respectful submission, that clause 5 cannot be read or interpreted to say that it has totally excluded the scope of appointment of an arbitrator or an arbitration proceeding. Read with again the main 29, clause 29 in the main agreement, it makes it rather clear that if this first step fails, then it will fall back on that 29. That is my response. Otherwise, my lord, rest are already settled, taken care of. Law is very subtle. Question is, Lordship will see whether there is indication, there is sufficient indication wherefrom intention can be derived.
MR engineers, first clause.
That the first clause of MR engineers, 24 paragraph, word form, that whether that has been referred to and entirely it has been referred. Intention is clear that the whole body of the agreement will form part of this agreement. If that is so, no further reference is needed. Hirani has explained it. Therefore, my sole submission, whatever may be, that clause 5 will not in any way come in the way or bar the 24 application of clause 29 or sending the matter for arbitration. That's my sole submission, my lord. I think rest I have already submitted.
I also lied into MR engineers.
MR engineers, I am also relying on that NBCC.
Yes.
Those are very clear and those are already discussed in the Hirani developers case. Therefore, there is true.
Okay, we'll pass orders.
Yes.
We'll pass orders today itself, but Since councils are there waiting, will not pass orders in the court. Will not CAV it, will not reserve for, will pass orders, try to pass into this date.
Then in that case, may I beg leave of this court?
That is what we are trying to relieve you.
Yes.
You've been waiting for this matter since yesterday.
Yes. Yes.
Mr. Doctor is also waiting.
Lordship will keep it and pass the order, we'll get it to know.
My lord, if your lordship kindly give some precedence to this item 23,
We are in item number,
9, 10, probably.
Now we are, yeah, yes. Item 10 will
and
be.
let us see, we'll, in 23. Okay, let us finish the admission. If anything is long, then we'll take up your matter. Hopefully, the items are not long.
Lordship, I'm sorry
I
to,
will not be able to take up all the matters. I have to dictate that arbitration judgment also.
Lordship. Lordship, the last item, item number 38, Lordship. Here, my senior prayer is for the petitioner, Lordship. So if it can be fixed on 22nd.
38.
38.
Sakya? 22nd.
22nd, this month, Lordship.
Okay. Sri S. Tapin, learned senior government advocate, has made a request for adjournment to fix this matter, adjournment, full stop. Also heard Sri R. Sekal and the senior counsel for the petitioners who has not raised serious objection. Para, in view of the above, matter is adjourned to be listed on 22nd of June. Item number 38. Is there any interim order?
No.
Mr. Lampu?
Item number 16, 17 and 18, my lord.
Yes.
My lord, respondent number 3 has filed their affidavit yesterday, my lord. I need some time to file reply.
You're for the petitioner?
Yes, I'm for 57.
16, 17 and 18?
Yes, my lord.
On the prayer of H. Lampu, learned counsel for the respondents' counsel are there?
Yes.
Okay. On a prayer made by Sri H. Lampu, learned counsel for the petitioners, matters are adjourned by 3 weeks to enable filing of rejoinder affidavit. List on, we give a date, list on 22nd of, is it okay? 22nd of June.
Interim order. What is there?
Interim order passed earlier to continue till the next date of this.
All right, ma'am.
This will be an item 20, 15,
16 to 18.
16 to 18.
Yes.
Same
My
order,
lord,
same order, ma'am.
Yes, same.
can it be shorter, my lord? There, since there's an interim order, my lord.
We can give a shorter date.
My lord.
Let it be on 17, my lord, then.
Then we'll have it on 19th of June.
My lord.
19th June.
All right.
Deeply.
Same, common order, huh?
Item number 10.
Lordship, since for 3 occasions, Lordship, they were given the opportunity to seek instruction from Pharmacy Council of India. Since they have not come up with the instructions, Lordship.
No, Mr. Tapin has said yesterday that
Yes, Lordship.
we'll argue on how much time will it require?
Lordship, issue is only 1 point issue is there to be determined, Lordship.
No.
Whether that the Bachelor of Pharmaceutical Technology is equivalent to Bachelor of Pharmacy, Lordship. That is the whole issue that has to be
This is item number 10.
10, Lordship. Now, the recruiting agency, Lordship, that is APSSB.
What is Mr. Kaushik's matter? Where is he? Yes. What is your matter, Mr. Vedanta Kaushik?
This is relating to a tender process, Lord. Otherwise,
Why is it listed today?
it's for final disposal otherwise.
Final disposal, difficult. Yesterday we had
Yes,
Doctor.
I understand.
Doctor, we have retained him.
Otherwise,
with the assurance that we'll take up his matter.
I probably will have to take only 10 minutes, my lord. I can.
Now we'll try to have your matter, but we'll give slight preference to.
Yes, yes.
And even this matter we'll have to after some time. Let us try to have Mr. Doctor's matter.
Yes.
It may not take any time also. He's paying for this vacation of an interim order.
Item number,
Who is on the other side?
Lordship, I'm for the other side. Lordship, I think for disposal it
Item
won't be
number 30.
possible today, Lordship. Since
Disposal. IA.
IA also, Lordship, because the entire matter has to be heard, Lordship. Since contempt is pending against them, Lordship, Now then, can they, when contempt is pending against them, Lordship, can they?
Pending.
Correct, Lordship. Can they come up with this
This has,
IA?
everything has been done, only the results are required to be declared.
And no, Lordship. No, result was declared, stay was there from this honorable court. Then in spite of stay order, Lordship, they have functioned.
May I just begin
Just
first?
a brief idea.
Your Lordship may kindly take up IA 108. IA 108 is in writ petition 118. Well, before I take your Lordship to the IA,
These are the money.
well, may I just
Just a minute. Yes. Want to have our brief. One zero eight.
108. Now, Milord, what has happened? The subject matter in issue is the election of the Arunachal Cricket Association.
Yes.
Now, there was as per the constitution, my lord, the elections are to be held every year. It is the
After 3 years.
it is the body which is to oversee the functioning of the state association and its constituent members. So election is, sorry, my lord, 3 years.
3 years.
3 years. So the
Every
election,
3 years.
yes. So the election was notified. And after notification of the election, my lord, they came to the court. These writ petitioners came to the court complaining about various irregularities.
Election was notified when?
It was on 9th of February. 7th, but there is a dispute, my lord, with regard to the
9
date.
to 26.
26. We say that it was 7th, but there is a dispute with regard to the date, whether it was 7th or 9th. Now they come before this court saying that there are numerous irregularities in the process and therefore the process should be interfered with.
Yes.
The first writ petition that was filed was 63 of 2026, which is in item number 63 of 26 is item number
24.
24. The 63, now in 63 2026, this honorable court passes an order on 19th of February saying that election may go ahead in accordance with law and the decision and the result of the election will abide by the decision in the writ petition. That was the order. Thereafter, my lord, the elections were held on 24th of February as notified.
Yes.
After the elections were held.
When was it held?
24th of February.
24 to 26. Elections held.
Election held. Elections held and the writ petitioners, they were not elected. The other body came. 12th of March, my lord, they moved the second writ petition, that is 97 of 2026.
Yes.
And there they asked for a stay of the result of the election. This honorable court grants a stay.
Same petitioners.
Same petitioners. This honorable court grants a stay till returnable date. And the results of the election are on hold. That was on 12th of March.
Yes.
Since the result of the election was on hold, the new body could not come. The previously elected body took a decision that in the interregnum, so that the functioning of the association does not come to a standstill, the previous body will continue to operate as a stopgap arrangement.
Yes.
This decision was challenged in the last writ petition, that was 118 of 2026. And in 1/1/2026, an order was passed on 26th of March, staying this decision.
Okay.
This is the position. Now we have appeared and we have filed applications for vacating stay in two writ petitions, namely 118.
You are the association.
I'm the association and one of the respondents in the writ petition, who happens to hold the post of president. Our principal submission is this. First of all, my lord, since it's essentially an election dispute, where there are disputed questions of fact, that cannot be gone into any writ proceeding. That is number one. Number two, my lord, even if your lordships would require would like to examine the issues, my lord, there cannot be a complete ban on the elected body. They are defeated candidates. They cannot come and they cannot stall the functioning of a democratically elected body. They are relying on some decision, one of them being a decision rendered in the Bombay High Court, where an election process was put to challenge before the elections were conducted. And there, in the facts of the case, the Bombay High Court granted an ad interim stay and required the anomalies to be rectified and election process to be continued thereafter. In my respectful submission, my lord, that decision of the Honorable Bombay High Court, which they have referred and which is reported in 2026 SCC online page, Bombay 29, page 29. That is not 2026 SCC online, Bombay, page 29. Well, in my respectful submission, my lord, that is not an authority for the proposition that an election dispute can be, after the elections are held and after the results are declared, can be subject matter of scrutiny in 226 jurisdiction. Now, I'll briefly show, my lord, that why and how it is a disputed question of fact. First of all, my lord.
Now, that is questioning the maintainability. Correct.
Yes.
That is question. We are on the IA is for vacating the stay.
Yes.
Primarily for vacating the stay.
Primarily for vacating the stay.
You argue on the IA.
My lord, in the IA.
You argue on the and maintainability, then we'll have to give a full hearing.
No, I am for the present, my lord. Although, my lord, I have taken it also a ground that the writ petitions are not maintainable and therefore the stay could not have been granted. But for the present, my lord, I will be focusing only on the stay, my lord, stay part. My submissions are very short and precise. My lord, their contention is that this body, which was previously holding the charge of the apex body, it cannot function for the simple reason that that term of that particular body has expired, and therefore they cannot function. And in the garb of this, my lord, they are trying to interdict the process by making an application before your lordships to appoint an administrator in place of the previously elected body. That is also their case in IA 103. Their consistent prayer is that, come what may, neither the previous elected body nor the present elected body should be allowed to function. Instead, there should be a court-appointed administrator or a body of persons who will look after the affairs. My lord, my respectful submission is this, my lord. If they otherwise cannot maintain the prayer in the writ petition, because in 118, if your lordship will kindly see their prayer, my lord, that is just reiteration of the prayers, mostly, that they have made in writ petition 97. Well, on the same very prayer, how can you maintain two writ petitions? Rather, my lord, I would say, my lord, in all the three writ petitions, my lord, the prayers are common. And by failing at one point, because they come to the court passes, in my respectful submission, my lord, that was the most possible and probable order to be passed in a case of this nature. Court says that every decision in the election will be subject to abide by the decision of the court. Now they fail in
to 19.2.
19.2. That was the most appropriate order in the facts of the case, my lord. Now they make also make the prayer for stay and all. They don't get it. Now immediately when the result is declared, they come through a different petition, reiterating the same very prayers. They get partially they get an order of stay in the form of an order passed on 12th of March.
12-3. Let us see that order, 12-3.
12-3, your lordships will, may I just first show your lordship the first order?
First order we have understood.
12-3.
19-2 we have understood. 12-3, where is 19-2? Can page number?
19-2 is at, no. 26-3.
Very good.
26-3 order, your lordships will find at page 38. And page 41, your lordship will find that uh, 12-3 order. Page 45, your lordship can start from page 45 in 108. Well, may I just read out from second paragraph?
Yes, please.
The Learned Council further submits that page 45.
No, we were just reading the order at 26-3.
Oh, 26-3 will be, my lord, at
page 438. And
it will be at page 38.
okay, you want to read 45. What is there in 45?
45 is the first order, my lord, 12-3.
Okay. 12-3, second order.
Second order.
In 97.
In 97. The Learned Council further submits that when the petitioners found out that an election was contemplated without appointing an electoral officer, they approached this court by filing 633. And this court, by so-and-so, taking into account the projection made by the petitioners, directed that election being conducted will be subject to outcome of the writ petition. The court further directed that if the election is conducted, the same should be in accordance with law. Following the above direction, the respondents, for the sake of formality as an eyewash, engaged the respondent number 10 as the electoral officer only for 1 day only, that is the day of election. Then, my lord, the reference to the violation of the rules as they have projected. The third paragraph, your lordship will find the reference of 2026 Bombay High Court case, where, my lord, the stay was granted. And the third paragraph, in view of the above, issue notice of motion returnable by so-and-so, petitioner to take so-and-so. Having regard to the projection made, it primarily appears that the relevant provisions in the constitution of the association and the rules and regulations have not been adhered to, and therefore the impugned declaration of the result dated 24/02/2006 is stayed till the returnable date. We are affected by this, as well as the subsequent order, which your lordships will find at page 38. Now, so far as the Bombay High Court case is concerned, my lord, the matter was carried into SLP, but the SLP was withdrawn. Now, in page 38, the 26th March order is there, and your lordship will find from page 39, sixth paragraph, paragraph 6, it appears that WPC number so-and-so wide order dated a coordinate bench of this court has stayed declaration of result dated so-and-so till returnable date, fixing the matter on 6/4. However, in total disregard to the direction issued in the order, the respondents have deemed to have assumed the duties and responsibilities on 23/2, and also issued notification numbers dated so-and-so, circular dated so-and-so, show cause notice dated so-and-so. Thus, a prima facie case is demonstrated by the petitioners in their favor, and accordingly, the impugned office memorandum dated so-and-so, so-and-so, and circular dated.
What is the show cause notice?
Now, show cause notice were to certain constituent associations regarding some irregularities or irregularities committed by them. So the show cause notices were issued, and it was issued by the previously elected body. since there was an order of stay on the the new election, new elected body, result of the new election. So we said that to run the affairs in the interregnum, the previous elected body will continue until the time this stay is modified or this decision is delivered on WPC 97. So because of the stay order, my lord, now the situation has come to a position that neither of the bodies, neither the previously elected body nor the currently elected body are allowed to run the association. And instead, they want to utilize this ground to project a case before this honorable court that there is a breakdown of the system, so appoint an administrator. It is, my lord, I can understand that they are defeated candidate and projecting a case that, but for the alleged illegalities committed, it would have materially declared the result of election in their favor. It is also not their case. They are not saying that because if the illegalities were not there, we would have emerged elected. It is not the case. Who are the petitioners? They are the defeated candidates. If it is a case that we had a fair chance of winning the election and for the illegalities we were deprived, possibly that could have been a case. But in that case also, your lordship knows in election matters, never the stays are granted on the results of election. Well, the Tamil Nadu case your lordship has seen, because of the peculiarity involved, the Madras High Court had granted a stay, but it has been rescinded by the Honorable Supreme Court, saying that unless and until you come up with a definite case in an election petition, 226 jurisdiction is not open for utilization of that kind. Lord, here there is no election tribunal, but in the fitness of the things, Lord, at the best, Lord, they can go to the trial court. But even if they go to trial court, keeping the cardinal principles that are usually exercised in election jurisdiction, Lord, the results of elections are never stayed.
Yes, Mr. Jinit.
In such cases, lordship, after lordship, a leading case law that has come forth before the Supreme Court, lordship, in case of BCCI versus state of Bihar, lordship. Lordship is aware about Loda committee report, lordship. That was submitted subsequently, and a lot of changes was brought in. Lordship, similar way, lordship, and since this Arunachal Cricket Association is affiliated to BCCI, lordship. Lordship, in several judgments, lordship, I'll not refer to those judgments, lordship. It's clearly held that their function is public in nature. So they are said to be the state, lordship. So we can, if there is any collapse in the functioning of that particular body, lordship.
No, maintenance aspect will decide later.
Lordship.
Which, though Mr. Dutta has urged, we are on the aspect that in the first writ petition, there's an order that everything which will be held will be subject to the outcome of the writ petition.
Correct, lordship. But
thereafter, why did you again file 97 of 26?
Lordship, in fact, in that particular order also, lordship will kindly appreciate. In that particular order, one line direction was also given to the association, lordship.
Page? In the IA?
In the IA, lordship, I'll just read out that line, lordship. इसको तलाई क्या है? ये तो IA में कौन सा line? ये क्या? No, yeah. I think they have not annexed that order, lordship. In their
First order is not annexed, Mr.
First order is they have not annexed.
First order is not annexed, Miller.
I'll just read out that line, lordship.
19.2 is not. In the writ petition, they have annexed it. In 118 writ petition, Miller, they have annexed it. And
118, where is the page?
65, page 65. 61. And at page 63, your lordship will find the order.
Considering the submissions, not very provided that appears to have not been followed, have been not followed. Here, the board shall be subject to the outcome of the anything then be conducted in accordance with law. Yes.
And on the same very ground, the subsequent writ petitions were filed with the same very prayer.
This 63 is alive, isn't it?
Lordship, all the writ petitions are alive, Lordship.
So, no, 60, the others are alive. 63 will decide the issue. Why do you state?
Lordship, here in fact, one line of direction, Lordship, that I'm reading out, Lordship. Considering the submissions of the Learned Council for the petitioners and prima facie the constitution of Arunachal Cricket Association in respect of preparation of electoral roll as well as appointment of electoral officer appears to have not followed.
Yes.
It is hereby provided that AGM election of the Arunachal Cricket is proposed to be conducted on so and so 24/2 shall be subject to the outcome, and if the election is conducted, same be conducted in accordance with law.
Yes.
That was the direction given by this honorable court in accordance with law, Lordship. Now, in this writ petition, Lordship, one of the candidate, Lordship, who was contesting, he has already completed his tenure, Lordship, 6 years tenure, Lordship. I can demonstrate, Lordship. Now, as per the bylaws, Lordship, he ought to have gone for cooling off period, Lordship. He cannot continuously contest in the election for more than 6 years, Lordship. Mandatory, he has to go for cooling off.
After 2 terms, you need to cool off.
Cool off, Lordship. Then they can contest, then they can go up to 9 years, Lordship, at the maximum.
That is in respect of one of the candidates.
One of the candidates, who is the president, elected candidate in the present suit, Lordship, case, Lordship. And who is the petitioner in this instant case, Lordship, in the IA, Lordship. That was not followed, Lordship.
So that will be so far as one of the members are concerned.
Yes, one of the members is concerned, Lordship. Who is the instant applicant in this IA, Lordship?
Grievance is not against the member, your grievance is against the election as a whole.
Election as a whole, Lordship, alleging that the electoral officer, Lordship, he was here in the state for only 1 day, Lordship, for conducting the exit. Now, Lordship, may kindly appreciate that. There, Lordship, I have annexed the incumbency board also, Lordship. Their tenure expires on 22nd October 2025, Lordship. Now, after that, they become functus officio member, Lordship. Their role is only to conduct the exam, Lordship. Elections, Lordship. Election. Now, in spite of that, they keep on functioning, Lordship. Then we agitated, Lordship, the election has to be conducted, Lordship. Accordingly, that election was conducted by by adopting a resolution, Lordship. I can show that the resolution, Lordship.
But you had participated in the election.
No, Lordship, that is wrong, Lordship. We never participated, Lordship. We are the president of the affiliated body of ARCA, Lordship, Arunachal Cricket Association, Lordship. That is wrong on the part of the applicant.
Not held.
Election was held, Lordship, inside the room, Lordship, not allowing us to participate, Lordship. No electoral was prepared. Now they come up with so many documents to show that electoral roll was. I can demonstrate, Lordship. There are so many illegalities that has been taken place, Lordship, while conducting the elections, Lordship. Now all those are coming out, Lordship. Now,
Reacting to his submission, my submission is, it's a election, where constituent associations are the electorate. So he as an individual may not have participated in it. He is the petitioners are president and office bearers of the constituent associations. The constituent associations were very much there. I can show it even from their representation that they filed before the election officer.
Mr. Dutta, this will require a deliberation.
Correct, Lordship.
You suggested it. We would not like interim order also to be extended indefinitely. You suggested date next week. We'll fix it for final disposal.
In the main case, Lordship, the allegation that we have alleged against them, Lordship. Now BCCI is also there, Lordship, representing. In such cases, we can take the assistance of the BCCI also.
Madam, you have your instructions?
In this case, very unfortunate. This matter we had prepared for some 20 minutes.
By the time this matter was already fixed on second. So, in a very short span of time, I didn't receive any instruction.
You get the instructions.
My lord, one thing,
In today's context, electronic, this thing is there, you.
my lord, in the 108, my lord, no objections have also been filed, where we,
118.
yes, IA number 108 in 118.
We have
108, we have filed an application for vacating stage, although last time the time was granted to them to file an objection.
we have filed, Lordship.
No, it is, copy is not served to us.
My younger colleague has, maybe he has. Oh.
My lord, at least, my lord, my respectful submission is that, my lord, some mechanism has to be put in place so that the body can function.
Written objection has been filed on 16.
Yes.
But, my lord, we have not been.
We have served the copy also, Lordship.
16.
Among the other, like the DCI also received. DCI will see.
My lord, we have not received it, my lord.
Whom do you serve then? J. Mobi has received. Who is J. Mobi or T. Mobi?
My lord, he is J. Mobi, but he says he has not received it.
Received.
Maybe they have misplaced it somewhere, Lordship.
No. We have been waiting for this matter to be done, my lord.
If they have not received, we'll punish them the copy.
No, you have also given an undertaking, so it becomes of importance. Nowadays, you need to give an undertaking also that you have served.
Yes.
Or if you are not being able to serve, undertaking that you serve in the court. Now see,
See the signature.
there should not be another litigation because of the signature now.
No.
No, he says it's not his signature.
My respectful submission, Your Honor. I haven't received it. I have received 2 copies.
See the second copy, see second page, next page, undertaking.
Undertaking is by them, my lord.
Yes, that they have served.
We have, in fact, as per my friend's instruction, a soft copy was also sent, Lordship.
That is regard to 103. That is regard to
But whose signature is this?
This is not my.
No, he is J. Mobi, it is not his signature.
That is a soft copy was received in regard of IA 103.
No, not the soft copy, this copy.
No, this is not mine. For 103, I have given consent. This because they have, Your Honor, served me a copy.
This should not happen.
Correct, Lordship.
Bar, it should not happen.
We'll correct it, Lordship.
You serve a copy, 16 you have filed, today is what?
Today is third.
You could have done it yesterday also.
We were of the impression that the copy has been already served.
Signature is this? Or somebody else? No, somebody else has received on your behalf. No, it's not a signature. By somebody else. Who's this? 16.
My lord, just for clarification, IA, they have filed one in 103 IA, they have filed one rejoinder. I received that so by soft copy, then I have consented. And regarding that, I haven't received.
No, this is in 108. This is written objection in 110, IA 110.
No.
26. Okay, nonetheless. When tell us that the consent did.
Mother, it can be on 10th of this month. Huh?
10th, don't put on. Yes, 10th is possible. Next Wednesday.
Next Wednesday.
It's possible.
But if your lordship kindly considers the prayer in 108, my lord, otherwise I would not have said. If your lordship will see the prayers in the writ petition, except for habeas corpus, my lord, they have sought every kind of read possible. And that is also in one petition.
Prevent somebody from asking. We may not give them.
No.
How can you prevent from asking?
And my lord, interestingly, this 103, one miscellaneous case filed in all 3 writ petitions. I do not know, my lord, my limited knowledge. One miscellaneous case in 3 writ petitions, how it is maintainable?
Cannot do. One IA can be connected with only one writ petition.
Yeah, we'll undo that.
You can file 10 IAs in one writ petition, but you cannot file one IA in 10 writ petitions.
And my lord, this is the modus operandi is very disturbing, my lord. They file a writ petition, they fail to get the interim order. With the same prayer, they make.
That was one of the considerations for us in while hearing you, that whether this stay is to be vacated But there are other issues which we'd like to deal in one go and finish it off.
But my lord, in that case also, my lord, it will consume time in the sense that the question.
When is the next?
But my- in that case, my lord, if your lordship taking up the maintainability as well, my lord, perhaps that can be a situation, but until and unless your lordship gives some sort of a protection, apparently, my lord, my submission is that the kind of order that they have got from this honorable court, my lord, it is, this is usually not passed in election.
Yes, normally, but when is the next? Oh, heard 3 hours Jatto and the Senate Council assisted by H. for the applicant. Also heard Sri J. Ginny, then counsel for the opposite party with petitioner. Full stop. Though Sri Ginny, the Learned Council has submitted that. No, Sri Ginny, the Learned Council has submitted that objections have been filed and has also contended that copy of the same has been served upon the Learned Council for the applicant. Full stop. Sri Datta, the Senior Council has, however, submitted that copies were not received by any of the council on record. Be that as it may, let a copy of the objection be served to the Learned Council for the applicant during the course of the day. This court is also of the opinion that considering the facts and circumstances involved, instead of deciding the IA, the writ petitions as such would be required to be heard. Since urgency has been expressed by Sri Datta, the Learned Senior Council for the applicant, by submitting that there is an interim order, the matters are directed to be listed for admission hearing on 10th of June.
Lordship, 8 I'll be out of station. I'll be going to Teju, Lordship. Coming back, 10 won't be possible. Can it be after 10, Lordship?
Then, but 10, if it's not 10, then 12.
12 will be difficult, my lord.
Because 11th will be a DB day. Don't take a chance on DB.
And otherwise also, my lord, 12 will be the last working day, my lord.
Not 12.
My lord, for that particular bench.
Then try on 15th, Monday. 15th. The Learned Council would also be at liberty to pray for upgradation of the matter.
Well, till then, if your lordship makes the somewhat some mechanism, my lord, so that the show can go on.
Right now, we're not touched. Let us see.
August.
Item number 10.
What is 10?
Oh, 10.
Can your matter?
Matter regarding the
Pharmacy.
pharmacy.
Let's see this.
Lordship, in this instant case, Lordship, basically the petitioner is aggrieved by the selection process of the Arunachal Pradesh Staff Selection Board.
Who are you?
Lordship, I am a candidate who has participated in an interview process, Lordship, conducted by APSSB.
Selection process.
Correct, Lordship. By APSSB, Lordship. For the post of
Selection for?
pharmacist allopathy, Lordship. For the post of pharmacist allopathy.
Pharmacist allopathy.
Correct, Lordship.
Through the APPSC.
APSSB.
What is that?
Arunachal Pradesh State Selection Board, Lordship.
Okay.
Constituted in the year
How many
2000.
petitioners? One petitioner.
Only one petitioner, Lordship.
One petitioner. You participated.
I
Candidate.
participated, Lordship.
Candidate.
Candidate, Lordship.
Okay. Selection held.
Selection held.
You were unsuccessful.
Lordship, I was successful. I was the topper, Lordship.
Topper.
Lordship. I secured 159.5 marks out of 200, Lordship.
Yes.
In the final selection notification, Lordship, I could not find my name, Lordship.
How did you get your marks? RTI?
through RTI, Lordship. No, Lordship, through website, Lordship. There was a window period wherein we could download the mark that we secured, Lordship. It was provided to the all candidates, Lordship. Through that, I obtained my marks.
Was published in website.
Website.
You got your marks.
I got my
But your name was not there in the selection.
selection list. Mark sheet, Lordship, I have annexed.
Okay, thereafter, that is your grievance.
Lordship, when I hesitated before the authority concerned, Lordship, since I was the highest mark scorer in that interview, Lordship, and then there was certain reservation for non-APST, Lordship. 5 seats were reserved for
You are
non-APST.
an APST candidate.
Non-APST candidate.
You are non-APST.
Correct.
Was there any reservation
Up
for non-APST?
5 seats were reserved for non-APST, Lordship. Out of 5, only one non-APST was recruited, Lordship. Since I was the topper, Lordship, I'm supposed to be
One non-APST.
only one out of 5, Lordship. Seats, 28 seats was advertised, Lordship.
Okay.
Now, when I hesitated, Lordship, the reason was that my degree, Lordship, that I obtained from Maulana Abdul Kalam,
Fourth degree.
not forged, Lordship. The particular degree name is different, which they sought. They say that it should be Bachelor of Pharmacy. Now, my degree provided was Bachelor of Pharmaceutical Technology. But then, Lordship, in the RR,
Petitioner, you have, what do you have?
Bachelor of Pharmaceutical Technology.
Technology. And they want what?
Bachelor of Pharmacy.
Requirement. Bachelor of Pharmacy.
Correct.
Okay.
That was subsequently clarified by the university where I have studied, Lordship. That also I have an ex, Lordship. They say that the university says that the degree name, Bachelor of Pharmaceutical Technology and Bachelor of Pharmacy is synonymous.
Yes.
Further, the state was also directed, Lordship. They have also sought the clarifications. The clarification is the same. They have, in fact, they have come up with their affidavits, Lordship. In the affidavits, they have clearly said that the degree is synonymous, Lordship.
Yes. Now vacancies are there.
One vacancy is there, Lordship.
Protected by this.
Not protected, but in the final selection list, Lordship, that was published. In that selection list, it was clearly mentioned that one post out of 28 posts, 27 was recruited. One post was kept vacant since there was no candidate eligible.
That post belongs to non-APST.
That, Lordship,
APST.
APST.
On merit, Lordship, all the posts have been already reserved by the APST. Lordship. One non-APST is there, Lordship. On merit, they have occupied, Lordship. Now, in the last one post is left out. That is for APST, Lordship.
Right.
So that is your case.
Lordship, basically that is my case, Lordship.
There were clarifications given by our university that both the expressions Bachelor of Pharmaceutical Technology and Bachelor of Pharmacy is the same. They have also sought clarification in their affidavit. They agree that both are same. So yes, Mr. Tapin, who will respond, you or Mr. Tagore?
I'll respond.
Okay.
Lordship, kindly see the Lordship.
Now, are you agreeing with he has said in the affidavit, you agree that these are the same degrees?
No, we are not agreeing on that, Lordship. Whatever the state has produced along with his affidavit, this is only the response received from the Lordship university, Lordship. But state has not commented anything on that, Lordship.
No,
In fact, Lordship, that was not the in response to the letter written by the state, but to the Pharmacy Council of Arunachal Pradesh, Lordship.
No, those literature or whatever clarification, you need to either take, reject or accept. If it has come from the university, what is the difficulty in accepting?
Here, Lordship, because that clarification was sought by the State Pharmacy Council, Lordship, which is a statutory body, I think.
Yes.
Or
They have
and
sought.
that clarification was not sought by the state government, Lordship.
Hmm.
We have not, as I have submitted yesterday also, we have sought clarification of Pharmacy Council of India, Lordship, who prescribe this syllabus and approves the Lordship, this particular degree.
That answer has not come.
That Lordship, because we are dependent on their response only, Lordship. It's not,
that has not come.
we have not yet received, Lordship. So therefore, because I have only taken twice, Lordship, adjournment on that particular point, so I was. Lordship may see, Lordship, kindly take up the advertisement itself, Lordship. Advertisement.
When did you write to the Pharmacy Council?
Pharmacy Council.
So in fact, in this regard, Lordship, page number 112 of merit petition, Lordship. PCI has already recognized that university where I have studied, Lordship. This 112, Lordship. Pharmacy Council of India, Lordship. This is the list of the institute which is recognized by PCI, Lordship. This particular documents I have downloaded from the website of PCI, Lordship. Lordship, we find in the page 114, code number page 114. Now this is the recognized universities or the institute which is recognized by PCI, Lordship.
Where are you?
Page number 114, Lordship.
Which one?
1733, down below, Lordship.
Guru Nanak.
Guru Nanak Institute of Pharmaceutical Science and Technology. Here clearly, Lordship will see B from extended approval up to 2020-24 academic session for 100 admissions. It is well recognized by PCI, Lordship. And moreover, Lordship, the course that has been prescribed.
Mr. Jini, the university's recognition or affiliation is not the issue. Issue is with regard to the degree.
So, well, Lordship.
They are not questioning Guru Nanak. They are questioning B Pharma and B Pharma Technology.
Correct, Lordship. So, why, Lordship?
On that,
Pharmacy counts. Pharmacy.
On that, do you have anything to throw light on the clarifying the issue?
Correct, Lordship. I am coming to that, Lordship. PCI, they recognize, Lordship. It's very clear from this particular documents. Now, PCI will prescribe a syllabus, Lordship, that the particular student has to study, Lordship, while taking up that particular course. Now, I have annexed all those in my Lordship will see those all in my mark sheet where I have studied, Lordship.
Page,
Starting from page 32, Lordship. Thirty-two, 33, 34, 35, 36. Now this all subject that I have studied, Lordship. Lordship, same subjects, Lordship. That was part of the syllabus that was prescribed for the interview, Lordship.
no, this we cannot perhaps go into. Obviously, you, without
That is the same syllabus.
part of your syllabus, you would not have talked in the interview. Those are different, but we want to be very sure about the aspect, whether we pharmaceutical technology is equivalent to B pharma.
So, well, Lordship, that is already been clarified by the institute, Lordship.
Where?
Lordship, it's there in their affidavit, Lordship.
Which?
Affidavit of respondent number 3, Lordship.
Page?
Page 244. Since I am also one of the member of Arunachal Pradesh Pharmacy Council, Lordship. I have enrolled myself in this council, Lordship, Arunachal Pradesh Pharmacy Council, Lordship. Page 244. This is the affidavit that they have filed, Lordship.
244 is in lecture.
Lordship, annexure, Lordship.
4th April.
4th April
What
2025.
is this?
This is a letter addressed to the registrar, Lordship, Maulana Abdul Kalam University of Technology, seeking certain clarification.
Okay.
Whether course is Bachelor of Pharmacy, Lordship will see that clarification sought. One is whether course is Bachelor of Pharmacy or Bachelor of Pharmaceutical Technology, which is
But this clarification was sought from whom?
Lordship from the university, Lordship,
Which
where I have studied.
You studied in some other university, Guru something, Guru Nanak.
Lordship, that is affiliated to this university, Lordship.
Where do you get?
Lordship will see that the particular documents which I have showed, Lordship. Page 144, Lordship.
144. Yes.
Lordship. Lordship will see in the third column, Guru Nanak Institute of Pharmaceutical Science and Technology. Oh, 114. Sorry, Lordship, 114. 114.
Yes.
Guru Nanak Institute in the third column, Lordship. Guru Nanak Institute of Pharmaceutical Science and Technology, Nilgunj Road, Panihati, Kolkata. In the last column, Lordship, Controller of Exam Maulana Abdul Kalam Azad University of Technology. Certificate. And moreover, Lordship, page 30 and 31, Lordship. Page 30 and 31 also.
Where is the answer of this 244?
Lordship, page 31 also, Lordship.
No, what is the answer of 244?
Answer, Lordship, in the next 246, last page.
240.
246.
Yes.
First answer is Lordship, a certificate title to whom it may concern bearing reference number so and so dated 8 April 2020 has been issued by Maulana Abdul Kalam Azad University of Technology, West Bengal. It certifies that Apurva Roy, who is the petitioner here, Lordship, registration number so and so has been awarded the Bachelor of Pharmaceutical Technology degree from, in short, they have written Maulana Abdul Kalam University of Technology, Lordship, which is equivalent and synonymous with the Bachelor of Pharmacy degree.
What else do you need, Mr. Kapil?
Lordship,
What else?
Lordship, therefore, Lordship, I was taking Lordship to the advertisement, Lordship. I'm coming to the point, Lordship.
Because your
If he has completed, then
your endeavor to get the matter resolved or clarified by the pharmaceutical what is it?
Pharmaceutical Technology.
Pharmacy Council of India did not evoke any response. There is a clarification by the university that B Pharma and pharmaceutical engineering technology is same, equivalent.
Lordship, equivalent or synonymous is not our demand, Lordship. That is not recognized under the Lordship recruitment rule, Lordship. Not even in our advertisement, Lordship. There are lots of judgment, Lordship. Equivalence, this honor court will not decide whether those are equivalent or not, Lordship. There must be some sort of notification, Lordship. Some degrees are equivalent or not. But that will be subject to the recruitment rule. Recruitment rule, if says prescribe for particular degree, then that degree, the candidates having that degree only will be eligible for that, Lordship. There's a law, Lordship. I'll be placing this, Lordship.
Okay, let's complete.
Yes. Let him complete.
The point the state has raised, Lordship, that is one of their point that my candidature in this particular advertisement, Lordship, in the selection process was rejected. I was pointing out that, Lordship, in the RR, Lordship, for to be elected is to be in the post of pharmacist LPT, Lordship. RR says that 100% recruitment and the qualification requirement is the diploma in pharmacy, Lordship. The point which my learned friend is trying to her, Lordship, agitate, Lordship, is that, Lordship. As per the RR, it is the diploma in pharmacy, Lordship. However, Lordship, that part was already clarified, Lordship. One letter was written, Lordship, that I have annexed, Lordship. Page number 65, Lordship, of my petition. This is the letter written by Secretary Health to the Secretary Arunachal Pradesh Staff Selection Board, Lordship, to consider. This is the type copy, Lordship. Original copy is not legible, so this is the type copy. 64 is the copy, Lordship. This is the type copy. It reads, Lordship, this is to inform you that the Arunachal Pradesh Pharmacist Association has submitted a memorandum in which it has been requested for inclusion of D Pharm, B Pharm, M Pharm, Doctorate of Pharmacies, Doctorate of Pharmacy and PhD recognized by Pharmacy Council of India and registered under Arunachal Pradesh Pharmacy Council in qualification criteria for recruitment in the recently advertised post of pharmacist by advertisement so and so. In this regard, above qualification mentioned in the para are higher qualification than the prescribed in the advertisement. It is presumed that those with higher qualification automatically become eligible for appearing in the recruitment. It is requested to confirm this. In case position is not so, I would like to request to include all the qualification mentioned above to be allowed to appear in the test interview. Accordingly, this letter was written and modern DPharm, Diploma in Pharmacy, modern B Pharm, M Pharm, doctorate, even they participated and they were recruited, Lordship. Some of my colleagues we were recruited, Lordship. They were having the degree of B Pharm. I am being instructed, Lordship. That was allowed, Lordship. And moreover, Lordship, in this regard, Lordship, I have a citation, Lordship. The point that the state are raising, Lordship, the APSSB is raising.
By this memorandum, they had requested that the higher degrees should also be taken into consideration.
It was considered, Lordship.
Now, the question of you is not of a higher degree. Yours is a degree whose nomenclature is slightly different.
Lordship, yes.
You cannot equate with a D Pharma, Doctor of Pharmacy. Yours is at the same level, bachelor's level.
That is,
but there is a pharmaceutical technology.
Correct.
Now,
that is clarified, Lordship, by the
that clarification would require.
Lordship, so why? The clarification is clarified by the institute, Lordship. That clarification sought by the Arunachal Pradesh Pharmacy Council. Yes, that has been clarified, Lordship.
Yes.
2 points they are raising for rejecting my candidature, Lordship. One is that, Lordship. Another is this, Lordship. They say that in the RR, they want diploma in pharmacy. My degree was Bachelor of Pharmacy, Lordship. Higher than the DPharm. So they say that it has to be diploma in pharmacy. They are saying that. So why these clarifications that I...
Requirement is diploma. In RR, requirement is diploma.
Diploma, Lordship. Lordship, in fact, I am having the more than that degree, Lordship. Automatically, diploma subject, I study more than that, Lordship, in the bachelor, Lordship. Obviously, Lordship. The case will be like that. In this regard, Lordship, in this very point regarding the RR and then requirements in the advertisement, and if you have more than that required degree, Lordship, I have a citation to place, Lordship. This is of 2025, Lordship. Huh? And moreover, Lordship, since I was making my humble submission, Lordship.
This is which paragraph?
Paragraph 29, 30, 31, and 32, Lordship.
Mr. Kaushik, your chances are very less. You have to try another day. We have to write slightly earlier, you have to deliver a judgment. Mr. Mohanta's judgment. We thought of giving maximum accommodation, so we did not declare the judgment in the court. You can request for a date, court master will try. What is your matter?
Let's say
Petition.
tender matter, yes.
What you have participated in the tender?
I participated in tender. I qualified in the technical bid. Now, with the efflux of time, whereas my all 3 prayers have lost its force, but the only one prayer, because I'm alleging a fraud, where there is in the day when the minutes was open, there the rates which was quoted by the bidders was inflated and the award was given. And
that needs to be admitted by the respondent.
And they have alleged, they have not admitted, of course, they will not admit.
If they have not admitted, root code will be difficult.
And therefore, my lord, there was one complaint before the chief engineer. And with regard to minutes, which they have now brought in by way of, in the affidavit, I have also lodged an FIR because the signature against my firm, that is a forced signature.
You can
So-
pose your thing, we can give you liberty to
My lord,
pursue.
there is one prayer, my lord, which I have prayed in the repetition itself, my lord, directing the authority, my lord, that the chief engineer to cause an independent inquiry on this, my lord, because it is an online bidding process where everything is online.
You're against the Public Works Department.
Yes.
Who appear, Mr. Tapin appears. What about having an inquiry done?
My
He's
lord,
not talking about
my
the
lord, in
substantial
fact,
review.
his writ petition itself is liable to be dismissed with cost. The very document he has annexed, showing that he has quoted this amount, that itself is a fake document. That is not the financial bid, the rate quoted in his financial bid, which he has uploaded.
Wrong document has been enclosed in the
Yes.
petition.
Yes.
It is their allegation, my lord. But the document in the financial opening, the document which was shown in the computer, my lord, I have brought the photograph of that, having the geolocation of that photograph and the date. It was on 22nd of March when it was opened.
You, in the inquiry, you also look into this aspect?
Yes, that can be done into, because this is, in fact, my lord, I have an
If you have a counter allegation,
My lord,
in the inquiry, you look also into this aspect and you put responsibility.
My lord, in fact, he knows, he is the bidder who knows the rate, what he has quoted. He has not mentioned anything in his writ petition that I have quoted this much. He has shown one screenshot document saying that these are the amounts. Now, in our affidavit, we have annexed the entire financial bid of the participants, where he has quoted an amount which is not shown in that.
You have not been given any work thereafter.
No.
It is liable to be dismissed with cost.
Give him a work, new work. Everything,
My lord, let
everything
it be
will settle
heard,
down.
my lord. If not possible today, then any other day.
Then take a date of your conversation.
Yes, ma'am. Your
It will be
coordinate.
interesting case.
Yes, after vacation.
I have one more matter, my lord, item 19, my lord, I'll take a date there. In that matter also, my lord, the record was called for. I have been told that the record has come.
Retain the record.
Correct.
Number?
Item number 19.
I'm not supposed to respond.
My friend is there for the other second.
Do you need the records in the office? No.
No, madam.
No, I think madam is appearing for.
APPSC. APPSC.
No,
Narist.
Narist. Can you?
I'm appearing for respondent 6 in this case.
6, along with Madam Anju.
Yes, sir.
Now, we are giving a date. We'll ask you to retain the records. We'll not have the time to have it, Mr. Mazumdar, today.
My lord.
Okay. Okay.
And we have not filed our affidavit, my lord. Will give us opportunity to file our affidavit.
Okay. July 23. B. Kaushik, Learned Counsel for the petitioner. Also heard Sri D. Mazumdar as senior counsel, appearing online with the assistance of Ms. N. Anju for the respondent.
Assisted by J3.
J3 for the respondent 6, who submits, who prays for time to file affidavit in opposition. Ms. Anju, the learned counsel for respondent number 1 to 3 Narist has informed this court that the records have been received by her. Para? In view of the above, matter is adjourned to be listed on.
Can it be 22nd, my lord? It's not in.
22nd, can
July.
you file the 22nd by 22nd?
22nd of July.
July? On 22nd July, by which time the affidavits by which readings are to be exchanged. The records may be retained. But the records may be reproduced on the next date fixed.
Lordship,
I'll have to.
Lordship, I represent 4 and 5.
14 also, on 22nd.
I represent 4 and 5.
Mr. Jini, G. Jini is present for the respondents 4 and 5. That is item number
19, my lord.
19.
All right.
13, 14 notes on 22nd.
13 and 14, huh? On request. 13 and 14 are separate orders, huh? Paucity of time will not permit the matter to be taken up today. On request, list on 22nd of July.
Grateful.
All separate orders, 13 and 14. Now we come back to pharmacy.
Lordship, in their RR, they, in fact, they sought for lower degree, Lordship, but we have the higher degree, Lordship. This judgment, Lordship. Lakshmikant Sharma.
Yes.
Lordship. Relevant paragraph is 20, 30, and 32, Lordship. 29, 30, 31.
Chandrasekhar.
Chandrasekhar, Lordship. In the present case, the respondent have qualified the appellants on the account of the fact that they hold 29, Lordship. Hold the master degrees in different subjects, whereas as per their clause 2.1.3 of FSS rule 2001 rules and the subject advertisement, the qualification educational qualification of a master degree is only recognized in chemistry subject, whereas for all other subjects.
You are reading paragraph?
29.
Okay.
In the present case, the respondent have disqualified the appellants on the account of the fact that they hold master degrees in different subjects, whereas as per clause so-and-so rules and the subject advertisements, the educational qualification of a master degree is only recognized in chemistry subjects, whereas for all other subjects, only graduation degree would be the qualifying criterion. We feel that there is no ambiguity whatsoever in the 2001 rules or the subject advertisement which can exclude the master degrees in subject referred to in the preceding part of rule so-and-so other than chemistry as being a valid qualification. The special reference to the master degree is given in the said rule only for those who have acquired their degree course in chemistry, subject for whom the minimum qualifying criteria would be a master degree in. However, so far as the other subjects are concerned, a person having any degree, be it graduation or post-graduation, would be equally qualified for the post in question. This is important, Lordship. Reading the language of the statutory provision in a literal sense and applying the golden rule of interpretation, this is only logical and permissible interpretation. Hence, we have no hesitation in concluding that if a candidate having undertaken a degree course in chemistry subject desires to apply for the post of, he must possess a master degree in that subject. However, if a candidate has taken college education in the subject of food technology, dairy technology, biotechnology, oil technology, agriculture science, so and so, then such a candidate would be qualified for the FSO post if he holds any one of the degrees, either graduation, post-graduation, or doctorate degree in any of these subjects. There is no logic or rationale behind excluding the candidate having master's or doctorate degree in this subject from taking a claim to the post of FSO, because such an interpretation would be totally unjust, arbitrary, and unconstitutional. Same like in my case, Lordship. In the RR, it says diploma in pharmacy, Lordship, but we have the degree of bachelor in pharmacy, Lordship. They cannot, it's a higher degree, in fact, Lordship. Here also, Lordship.
The ratio is not applicable in your case. The issue says that they will go strictly by the requirement of the recruitment. Recruitment says that so far as chemistry is concerned, you need to be masters. So far others are concerned, there is no requirement of masters.
Correct, Lordship.
So court has said we'll go what has been stated in the recruitment rules. In your case, you say that you have qualification which is higher than the required thing. You make out your own case that there cannot be any rationale behind excluding a person with higher degree.
And moreover,
no, there are cases where the court has upheld that holding of a higher degree will make you ineligible to even compete in certain posts.
But in my case, Lordship,
there are the cases where class 8 was the prescription, class 8 for grade 4. Or a master's degree had applied, He said, when 8 is qualified, why shouldn't I be qualified? Court has upheld the decision of the, because a master degree person, it may not be directly applicable to your case. A person with a degree of master's will not put in that much of effort which a class 8, and he will look for better opportunity. So he will not have dedication to the job. That is the logic. But that is the ratio we have to abide by. Here, it may not be directly applicable because it said instead of diploma, you are having a bachelor's.
Bachelor degree.
Only question is that but diploma and bachelor is not the issue. Issue is the bachelor of what? Pharmacy or bachelor of pharmaceutical technology. Whether pharmacy and pharmaceutical technology can be held to be equivalent, which you are relying upon the clarification given by your university.
Correct. That is one ground that they, in their affidavit, Lordship, they have said, and another ground is that also, Lordship. The RR, that part, Lordship, RR says that diploma in pharmacy, but you have the bachelor in pharmacy, Lordship. And then that letter, Lordship, from the Secretary of Health, Lordship, that was already clarified. The candidates were already allowed, Lordship, to participate, and accordingly they were recruited, Lordship. So they cannot single-handedly ousted me saying that you have a higher degree, Lordship.
Okay.
And one more, Lordship, in the page number 114, Lordship, regarding the recognition by PCI, Lordship, Pharmacy Council of India, in regards to that institute, Lordship. There also, Lordship, they have, PCI has recognized that course as Bachelor of Pharmacy only, Lordship. But then the degree, the certificate that was given to me, Lordship, was pharmaceutical technology. That is already being clarified, Lordship. The course recognized is B.Pharm, Lordship. Lordship will kindly come back, Lordship. Page 114, Lordship.
Yes.
It's very clear, Lordship. B.Pharm. In the middle column, Lordship, approval up to academic session, Lordship. That is B.Pharm only. The PCI has recognized for B.Pharm. But in the institute, Lordship, that the whole dispute is revolving around this, Lordship. I'll just like to show that that certificates, Lordship, which is under dispute, Lordship. Page 31, Lordship, page 31. Page number 31, Lordship.
Yes.
Here also, Lordship will see university is Maulana Abdul Kalam University of Technology. In the down below, Lordship, College and Institute is the Guru Nanak Institute of Pharmaceutical Science and Technology.
Yes.
Now, this Guru Nanak Institute of Pharmaceutical Science and Technology has been recognized by the PCI to run B.Pharm course, Lordship. But then the degree that has been, I have been conferred, Lordship, that is Bachelor of Pharmaceutical Technology in the middle, Lordship, will see, which has been subsequently been clarified by the institute itself, Lordship, in their affidavit, Lordship. So, Lordship, I'm the topper in the entire selection process, Lordship, in the exam, Lordship. So I have to be, Lordship, appointed, Lordship.
Okay. Yes.
Lordship, my submission would be basically what I understood. So far the law is concerned, that means goes against me or the other party law. If Lordship see the advertisement law.
Page?
Lordship, page 43, Lordship, double PC.
43?
43, Lordship. And relevant is page 50. This is the advertisement.
Relevant is the page?
Page 50.
50.
Because by these advertisement lawsuit, many posts were advertised lawsuit, having their own respective code number. And for this particular post, this pharmacist allopathy, the code assigned is 24/24 laws. It's reflected in at page 5506.
Yes.
Lawsuit will
What
find.
is the meaning of the postcode? Postcode.
Postcode laws.
For this
Postcode.
post,
Yes,
24/24.
for this particular post lawsuit. The education qualification and other qualifications lawsuit here. Class 12 science passed from the recognized institution or board with diploma in pharmacy. That is DPharm from any institutions or board recognized by Pharmacy Council of India and must be registered under the Arunachal Pradesh Pharmacy Council India Pharmacy Council. This is the lawsuit, the qualifications prescribed for this particular post law. It specifically says lawsuit the diploma in pharmacy lawsuit. Class 12 pass with diploma in pharmacy laws.
Okay.
And for reference, lawsuit may note, let's say, at page 231, this additional affidavit filed by the petitioner, where lawsuit the recruitment rule has been placed before the Honorable Court. Page 231 lawsuit.
Yes.
Here, the same qualification has been prescribed also. Recruitment rule. It starts from page 231 and relevant is at page 232 lawsuit. Column number 7 at page 232. The same qualification has been prescribed also. Because advertisement has to be issued in consonance with the recruitment rule only laws. And lawsuit may note that lawsuit the equivalency is not, the equivalent qualification is not invited here lawsuit. That part may be noted lawsuit. The lawsuit may take up my affidavit lawsuit. My affidavit. That's affidavit filed by respondent number 2 lawsuit.
Page?
Kindly come to page 191.
Well, this affidavit starts at which page?
It starts from page let's see 132 lawsuit. The annexure starts
117. Kodarathi.
Yes, yes.
16 September 2025.
Yes, correct lawsuit. The page 191 lawsuit.
117 your affidavit starts.
Yes, 117.
You want us to count to page
191 lawsuit.
At 191. Yes.
This is a lawsuit, the prescribed documents, which after having selected in the lawsuit written examination, the candidates who have been provisionally selected in the written examination, they have to upload these documents lawsuit. Here lawsuit will find the matriculation, so and so and so, and fifth is the diploma in pharmacy lawsuit. These are the documents we have demanded from the selected, provisionally selected candidates lawsuit.
Yes.
Now kindly come to page 193 lawsuit, after next page lawsuit. These are the documents furnished by the, uploaded by the petitioner lawsuit. Here lawsuit will find, this is the checklist lawsuit. Here remarks in remarks column lawsuit, we have remarked that Bachelor of Pharmaceutical Technology lawsuit. Whereas what we have demanded at serial number 11 is a diploma in pharmacy lawsuit. Serial number 11 lawsuit. So that remarks is your lawsuit.
No, remarks he has written. Who has written?
Lawsuit, this remark is by us only. Lawsuit. Lordship will find signature of verifying authority on the right hand side, and on left hand side the signature of the candidate, Lordship. And there's no doubt, let's say he top in the Lordship merit. There's no. Now, when we came to know that Lordship, Lordship, the day when Lordship physical verifications of the document, yes, Lordship, he could not produce Lordship this diploma in pharmacy, Lordship. So accordingly, Lordship, we have rejected the petitions candidacy. Because he has not fulfilled the recruitment rule and the conditions prescribed under in the advertisement Lordship. Then Lordship may kindly take up Lordship 234 Lordship. This is a affidavit filed by respondent number 3 Lordship. Lordship. This is so-called clarifications given by the Maulana Abdul Kalam Azad University of Technology, West Bengal.
His rejoinder.
His rejoinder, Lordship. No, not his rejoinder, Lordship. This is affidavit filed by the respondent number 3. Page 234, Lordship.
234 is, there's some confusion. Respondent number 3 affidavit is, who has filed?
By one Chera Tulu.
No. It's here. Page number 245.
Oh, Lordship 245. Page 245. In my here, pagination is
next 240 continuation.
239 it starts. By R3.
R3, Lordship. This particular document, Lordship, my friend has already, friend petitioner has already read before this court, Lordship.
Which one?
Page 245, Lordship.
245.
This is certificate issued, clarification certificate issued by the university, Lordship.
Yes.
May I read, Lordship, this?
Yes.
This is to certify that the student Apurva Roy, registration number so and so, roll number so and so, has been awarded Bachelor of Pharmaceutical Technology by the University of so and so and so, which is equivalent and synonymous to Bachelor of Pharmacy. It says equivalent and synonymous to Bachelor of Pharmacy.
Yes.
Then, Lordship, kindly say the next page, Lordship. This is the letter, clarification letter by the same university to the registrar cum secretary, Arunachal Pradesh Pharmacy Council, Lordship. From my authority and from the government level, we have written to the university as well as to the Pharmacy Council. We are yet to receive our instruction response from them. But this response is to the registrar from Arunachal Pradesh Pharmacy Council, which is a statutory body, which is not before us, Lordship. Even then, Lordship, I would like to read the serial number 1. It repeats the same thing, Lordship. It says it awarded to Bachelor of Pharmaceutical Technology degree from so and so, which is equivalent and synonymous with the Bachelor of Pharmacy so and so, Lordship. Now, Lordship, I'll state where I'll take Lordship to certain citations of Honorable Supreme Court, which says, Lordship, the equivalent, until unless that is recognized under the recruitment rule, that cannot be accepted, Lordship. They will not be eligible for that post, Lordship. And whether they are equivalent or not, Lordship, that has to be, Lordship, done through, Lordship, resolution or duly published, Lordship, by the particular university or by the Pharmacy Council of India, Lordship. Until unless that publication is there, Lordship, duly published notification, Lordship, that equivalency or lordship synonyms cannot be decided by this court lordship. On that points, lordship, I'll be placing some. The first citation lordship 2010-15 SCC 596 lordship.
2010?
2010-15 SCC 596.
Name?
This is lordship Jyoti KK and others versus Kerala Public Service Commission and others.
सुबह में list लेता हूँ सुबह में. List देता है. सुबह का list. सुबह का list. हाँ. कैसा नहीं देता. कैसा नहीं देता.
I didn't get.
You have a copy?
Lordship, sorry.
Can read it, paragraph?
Lordship, paragraph 678, Lordship. Lordship, here just the facts is like that, Lordship.
Jyoti KK.
Jyoti KK versus Kerala Public Service Commission, Lordship. 2015.
2010, yes, sir.
2010, sorry, 15 SCC.
596.
596. ये नहीं क्या? 2015 to SCC. Hey, okay. Then one more. 18 SCC. 546. And wait, 2026. SCC online. SC 88. आपको डेटा बोला नहीं वो तब दे दिया ना सुबह दिया था किसने I'm sorry for the inconvenience. Lordship, in this particular case, Lordship, the post is Lordship sub-engineer. Post is sub-engineer and required qualification was Lordship SSLC or its equivalent Lordship. Technical qualification, this SSC secondary, I think, secondary level certificate or its
required?
SSLC or its equivalent Lordship.
HSLC or SS?
SSLC.
Or equivalent.
Or its equivalent. And technical qualification Lordship, diploma in electrical engineer of a recognized institutions after 3 years course of study Lordship.
Diploma?
Diploma in electrical engineering Lordship. Or a certificate in electrical engineering from any one of the recognized technical school.
In electrical
engineering Lordship.
Yes.
Here the appellants are Lordship BTech Lordship. Because they were not selected Lordship. Because BTech is not Lordship demanded under this Lordship. Whereas in fact Lordship, BTech is a degree which is higher than this degree Lordship. Now what happened in this case? If Lordship, if I read Lordship paragraph 6 Lordship. 6, this is a part of the recruitment rule Lordship.
Yes.
The recruitment rule says Lordship, notwithstanding anything contained in these rules or in the specific rules, the qualifications recognized by executive order or standing order of government as equivalent to qualification is specified for a post in the special rules and such of those higher qualification which presuppose the acquisitions of lower qualifications prescribed for the post shall also be sufficient for the post law. What in this particular case, lordship, recruitment rule itself provide lordship. The higher, if person having the higher lordship, the degree, which presuppose the acquisitions of the lower degree lordship, they too they will be eligible. That is a prescribed in the recruitment rule itself lordship. Therefore, it was allowed lordship. The persons having BTech, they were allowed to lordship in the selection process lordship. That is a
BTech and diploma are entire different things. You cannot become a diploma and then become a BTech.
No.
There are different streams.
This is BTech degree in electrical engineering lordship.
The requirement was diploma.
Diploma in electrical engineering.
Or a certificate.
No, here, yes.
Or a
Oh,
certificate.
oh, yeah.
Now the appellants were BTech.
BTech lordship.
And yet they were given the benefits.
Here it's given benefit lordship by holding that the BTech degree is the lordship higher than the diploma in electrical engineering. Both are electrical engineering lordship.
So how is it going to help you? Because in your
No, I'm going to distinguish it in the later judgment, which
in your state, you have already taken a decision. The state at page at page 65, Secretary Health to Secretary of the AP Staff Selection Board higher qualification also eligible.
lordship may examine that aspect also, because whether that particular communication, because there is no like amendment of recruitment rule and all lordship. Whether that letter will lordship substitute or lordship can alter the lordship recruitment rule. That aspect
But this one which you have just relied upon, Supreme Court decision,
lordship.
the recruitment rule had talked about diploma in engineering, electrical or certificate in electrical engineering.
Correct, Lord.
In spite of that, a degree in electrical has been held to be eligible.
Lordship, because that's provided in the recruitment rule itself, lordship.
Where is the proper recruitment? You have just read out.
Recruitment rule, lordship, just which I have read out, lordship. Here, lordship, the higher lordship degree, the candidate having the higher degree also they will be eligible lordship. That particular lordship clause is there in the recruitment rule lordship. In this particular case, lordship. And in the present case, that lordship is not in the recruitment rule lordship, provided in the recruitment rule. मिल गया अभी हम लोग 2015 to SSC.
Lordship, in this regard, once a small, as I was submitting, Lordship, after this letter of page 65, Lordship.
We'll do anything. But, today, we'll have this tomorrow.
Lordship, I'm having tomorrow and day after tomorrow, I will be out of this.
Then you complete the rejoinder because we have to rise. The judgments will remain incomplete. Bench is still day after tomorrow. We have to deliver that order. When are you leaving tomorrow?
Today, this evening, after Lordship court, I will be leaving.
Then you can complete your part. How long?
Lordship, just I'm placing the judgments.
Just finish it quickly. Okay. But Mr. Ginny will have your part tomorrow.
Lordship, I'll just, then Lordship, I'll just submit one, I'll just quote the paragraphs and I'll just.
Of a citation?
Of the citation.
Okay, then finish it.
Then Lordship, 2015 to SSC.
This one?
Yes. State of Punjab and others versus Anita and others, Lordship. Paragraph 13 and 15, Lordship.
Thirteen and 15.
13 and 15, Lordship.
Yes.
Yeah, Lordship, just I'd like to read this paragraph 13, Lordship. A perusal of the apposite judgment leave no room for any doubt that it's imperative for the candidates to possess the statutory qualifications prescribed for appointment to the post to which they are seeking appointment. In view of the positions declared by this court, qualifications of B.Ed and other qualifications possessed by the private respondent, namely MA, MSc, MCom, etc., cannot be treated as higher qualification with reference to the prescribed qualifications of JBT-EET. We therefore find the reason accorded by DEO in the impugned order this was fully justified and in consonance with the legal position declared by this court as so and so and so. Then kindly come to paragraph 15, Lordship. 15. It was sought to be asserted on the basis of the apposite observation that since the private respondents possess higher qualifications than the qualifications of JBT/EET, they should be treated as having fulfilled the qualification stipulated for the post of so and so teachers. It is not possible for us to accept the apposite submissions of the learned counsel for the private respondent because the statutory rules which were taken into consideration by this court while recording the apposite observation in Jyoti KK case, which I have just read, permitted the apposite course. The statutory rule in the decision relied on by the learned counsel for the private respondent is extracted here and below, which I have read, Lordship. The rule 10, Lordship. Here, Lordship, just now I have read, Lordship, in KK case, Lordship. Here, by this rule 10, Lordship, higher degree, person having, a candidate having higher degree, they presupposes, Lordship, having acquisitions the lower degree. Therefore, they also may be allow. That is the language of the recruitment rule itself. Therefore, Lordship, higher, the candidate having the higher degree was allowed to be sit in the selection process in Jyoti KK, Lordship. Now, kindly come to. A perusal of the rule clearly reveals that the positions of the higher qualification would presuppose the acquisitions of the lower qualifications prescribed for the post. Insofar as the present controversy is concerned, there is no similar statutory provisions authorizing the appointment of person with higher qualification. Lordship. Here also exactly, Lordship, for higher is not, Lordship, recognized in the recruitment rule, Lordship. Then, Lordship, I'm taking, Lordship, to the, so many judgments, but I'm skipping only relevant, Lordship. 2023, 18 SCC. 2023, 18 SCC.
But this submission, how can you make in this will be in the teeth of your letter of 22/9/2024.
Lordship, that's what, Lordship.
Your secretary, health secretary has clarified that higher qualification will also be eligible. He knows about the recruitment rules.
But whether that...
How can you argue against this?
Lordship, therefore, in very beginning, I have submitted, Lordship, that what I understood the law, so far, it governs the Lordship.
But this is not even an issue which requires determination. Secretary has clarified on 22/9/2024. Your secretary, not their person. Secretary Health, and not to petitioner on here asking, written to the AB Staff Selection Board.
Hello, so therefore, that part I'm leaving this on court. Whether that letter can, Lordship, alter the, Lordship, supplant the, Lordship, recruitment rule or
No,
not.
it's not changing the rules. It is only explaining the rules.
This is a, Lordship, if Lordship see the letter, it's a clarification letter only, Lordship. This is not even the decisions of the government or by in the form of...
The consequent question will come from the court that whether the selected candidate, any of the selected candidate are graduates or are the diploma holders.
That part, Lordship see the legality of that part.
No, have you appointed any graduates? Any
Part-
degree holders?
That part, Lordship, because...
If it is your case, that in spite of this letter of 22/9/2024, you are arguing that recruitment rules should be followed, this letter should not be given importance or credence, then you have to make out a case that there is not even a single appointment where we had given a degree holder an appointment.
Lordship, just I'm placing the law, Lordship. And if the law is there, Lordship...
No, law cannot be for different for him and different for the other.
What I'm submitting, if that is the law, Lordship, then negative equality will not be applicable, Lordship.
It's the same selection.
Correct, Lordship.
It's not a negative equality.
Correct. Negative equality, because if that goes against the law, Lordship,
Then what action have you taken against them?
Lordship, that part, there's nothing on
Take
the.
action against them. Let us make things very easy for you. I'm
Lordship-
not using the word complicated for you. We'll give you a direction. If you are having a stand that we are not giving a degree holder, then you check.
Then, Lordship,
degree holder, take a stand, remove them from service.
Le-
From retrospective effect. Let there be a chaos in the state. You cannot take stand like this, Mr. Tapin.
No, I'm just placing the law.
Why
I'm not
you-
taking.
In view of the state secretary's letter, how he is the best authority. He knows the recruitment rules. He says that higher qualification will also be eligible.
Okay, okay. Just to make it easier, Lordship, just let's.
You concentrate.
I'm skipping the
concentrate
Lordship.
on the issue which is before us.
Yes.
He is a person who has a degree which is not exactly the degree which you require.
Correct, Lordship.
You require a diploma. Secretary has said that even a bachelor will do, but his bachelor is not on pharmacy. His bachelor is on pharmaceutical technology.
Lordship.
And there is a clarification given by the this university that this should be treated at par.
Correct, Lordship. Anyway, therefore, I'm submitting. Therefore, in beginning, I've said, Lordship, what law, just I understood that I'm placing before this one court, Lordship. That also the action of mine only, Lordship, that letter by the secretary, that I understood, Lordship. I'm assessing this one court, what is the law, I'm trying to place the law only. Anyway, Lordship, then Lordship kindly come to, then I'm concentrating only on the issue, Lordship, the equivalency, whether that's, if that's not recognized under the recruitment rule, whether that can be permitted or not, Lordship. And whether they are equivalent or not, whether that can be decided by the Sonal court or not, that part also. Then 2023 Lordship, 18 SCC. 2023 18 SCC.
2023.
18 SCC 546.
2023.
546 Lordship.
2023, what SCC?
Paragraph 12 and 13.
No, give the citation, please.
2023 18 SCC.
18 SCC.
18 SCC.
543.
546.
546 name.
This is Uni Krishnan, CB and others versus Union of India Lordship.
Paragraph.
Paragraph 12 and 13 Lordship.
What ratio?
Ratio on Lordship, so far qualifications or declare or to declare the equivalency of the course. The court will not Lordship go into Lordship.
Please read.
Just may I read because this paragraph is very vast, Lordship. May I? May I read just relevant portion? No doubt, the said rule is silent with regard to diploma in civil engineering being either 3 years or otherwise. It is an undisputed fact that the appellant possesses diploma in DED and not diploma in civil engineering. It is trite law that courts would not prescribe the qualification and oblique or declare the equivalency of a course until and unless rule itself prescribe equivalency, namely different courses being treated alike. The courts would not supplement its view or substitute its view to that of the expert body Lordship. Just I'm reading rest as well, Lordship. And paragraph 13 also is there, Lordship. 13 says, Lordship.
Yes.
So this court has reiterated that equivalence is a technical academic matter. It cannot be implied or assumed. any decisions of the academic body of the university relating to equivalence should be by a specific order or resolution duly published, dealing specifically with whether a distance education courses was equivalent to a degree of MA of the appellant university therein. The court held that no MA had been produced before it to show that the distance education course had been recognized as such. Here also, lordship, it says the equivalence is a subject matter to be decided by the university, and that has to be that has to be done by way of resolution duly published in the lordship. Then one very interesting judgment, that is lordship, the last judgment I am placing. That is 2026 SEC Online SC, page 88, lordship.
Page 26.
2026 SEC, Online SEC, 88. Page 88. 88.
Name?
This is lordship, Muhammad Piroj Mansoori and others, State of Bihar. Muhammad Piroj Mansoori and others versus State of Bihar and others, lordship.
Yes.
Lordship, this lordship just paragraph 8, 9, 14, 52, 56, 59, and 61, lordship.
8, 9, 14, 15, 52, 8, 9, 14, 15,
52, 56, 59, and 61, lordship. This is exactly, lordship, what happened in this present case, lordship. Here, the as per rule, lordship, this in connection to the State of Bihar, lordship. This is for the pharmacist, lordship. The prescribed qualification is, lordship, diploma in pharmacy, lordship.
Prescribed qualification.
Diploma in pharmacy, lordship.
Yes.
But the petitioner here, appellants here are, lordship, Bachelor of Pharmacy and Master of Pharmacy, the appellant, lordship.
Yes.
The same thing, lordship, the Honorable Supreme Court said, the recruitment rule is prescribed the rule of diploma in pharmacy, lordship. Though you are having a Bachelor of Pharmacy and Master of Pharmacy, lordship, cannot be accepted. That is the lordship, the recent judgment 2026, lordship. This lordship, just why I said, lordship, negative equality. There's something given in violations of the law, lordship. Then same benefit if someone is asking or is given, lordship. So on that aspect only, lordship, I said negative equality is not, lordship. So that's all, lordship.
Endorse the submission. It's for respondent number 3, Satagum.
This has already been. Tagum is for
Health Department.
Health Department, respondent number 3, who has sought the clarification from the institute.
No, he has not sought.
My lord,
He has not sought.
there's a Arunachal Pharmacy Council, my lord.
the Arunachal Pharmacy Council.
My lord, we are under the same department only.
Health
and-
department.
Yes,
Health
my lord. Under control of the same government.
And we've taken assistance from there because they are the authority who maintain the role, my lord. Whoever pharmacist graduate or eligible, they get registered in the Arunachal Pradesh Pharmacy Council. So we have to take assistance from them. So accordingly, as per register of Arunachal Pradesh Pharmacy Council, they have the sought clarification from the concerned university. Because first they have registered as a pharmacist under Arunachal Pharmacy Council. They produced the provisional certificate wherein it was bachelor in pharmacy. But later on, when it was original, when it produced, it was written as Bachelor of Pharmacy Technology. So that's why this all thing come up. Man. Accordingly, they have given clarification saying that it is equivalent and synonymous. Man. That's part, man.
Okay. Yes.
Lordship, since one post is remained vacant, Lordship.
Finish it.
Lordship, I'll just finish in 1 or 2 minutes, Lordship. Lordship, since that one post is remained vacant, Lordship, that has to be.
Post is not vacant, Lordship. It has been already filled up.
No, Lordship.
By APST on merit, Lordship. But submitting those is a vacant is lying, Lordship. Because one post which was left out, Lordship, that is meant for APST, and in subsequent, Lordship, advertisement, that also has been included, Lordship.
No, Lordship. After filing of this writ petition, another writ petition was filed, Lordship, which was subsequently withdrawn, Lordship. In that writ petitions, clarification was sought from the APSSB whether that particular post which was kept vacant, whether it was carried forwarded, Lordship. Their instruction was that it was not carried forwarded. So why I did not insist for the interim stay of the recruitment process, which was being conducted subsequently, Lordship. That was their instruction, Lordship. So as per instruction, Lordship, till date, one post is remain vacant, Lordship. Lordship, that apart clarification from the universities and all, Lordship, that is very much clear, Lordship. Another aspect that I wanted to highlight, Lordship, is the subject that I have studied, Lordship. In the initial stage, Lordship, I have already submitted that, Lordship. In that regard, Lordship, I have a case law, Lordship. Even if the name of the course is different, Lordship, what has to be seen is the course that I have studied, Lordship. That particular citation is Lordship, in my petitions, Lordship, I have annexed all those mark sheets where the subjects are being mentioned, Lordship. Now the same subjects which I have studied, Lordship, it's been prescribed by the APSSB for conducting the interview, Lordship. Lordship has clearly observed that since I have taught in that interview, obviously I have studied those papers, Lordship, properly.
Why are you citing this? 25?
20, 31, 32, 43, and 44.
What position?
On the position that even if the course name is different, Lordship, they say that my course is Bachelor of Pharmaceutical Technology. Now their requirement is Bachelor of Pharmacy, Lordship. Even if presume
Diploma.
Lordship, that is again the different aspect, Lordship. I'm coming to the second aspect, Lordship, regarding the name of the degree, Lordship.
Lakshmikant, which paragraph?
Here relevant paragraph would be 20, 31, 32, 43, and 44, Lordship. I'll just read out that paragraph 32, Lordship, which is very much relevant to my case, Lordship. On perusal of such circumstances, we are of the opinion that insisting solely on the title of the degree without considering the actual curriculum amounts to elevating from form over substance. The law does not compel such interpretation. In our view, considering the facts of the present case, the expression postgraduate degree in statistics must be understood contextually and purposefully. Lordship, in my case also, Lordship, since the course was the same, only the degree name was different, Lordship. That also subsequently been clarified by the institute. Now what remains, Lordship? Nothing, Lordship. So why, Lordship, my humble prayer would be, Lordship, to direct the respondent number 2, no? APSSB. 2 to recommend my name for appointment to the post of pharmacist allopathy, Lordship, retrospect, with all the consequential benefits, Lordship.
Okay. Diploma. Is up to date. We do not know whether we are able to deliver the judgment by day after tomorrow. JGN. As Captain Senegal. Titagum, standing council else. Hearing is concluded, judgment is reserved.
Should we continue or we-
No, right.
the remaining?
Remaining already given dates. Any matters where dates you would require, kindly request the court master.
Lordship, just I wanted to inform this Honorable Court, Lordship. Yesterday, one matter, DB matter, the tender matter was heard. In that case, Lordship, record was already placed before this. That may be noted, Lordship.
It's a DV matter.
DB matter.
No, CAV matter.
CAV matter. Yesterday, that BMG Belgia item number
Yes,
4 and
yes,
5.
item in DB matter.
Which one was that?
Yesterday, all day, that matter only is.
See,
What was the
Lead Appeal 1 of 2026.
No, not, what was the subject?
Lordship, that tender, Lordship. The extended tender, that issue.
Oh,
Extended tender.
yes.
They are
The
actually.
bridges, 6 bridges.
Yes, 6 bridges. The records was placed before this earlier, Lordship. Yesterday, I forgot to inform this records is there, Lordship. Or any perusal, Lordship may.
To incorporate this.
May I please, Your Lordship. Lordship, item number 21, Lordship. Lordship, this is regarding the appointment of additional public prosecutor for the District and Sessions Court, UPR, Lordship. Regarding this, Lordship, in the last occasion on 25th, Lordship, May 2026, this Honorable Court has directed to take steps upon the respondent number, private respondent number 8, 9, and 10 through Dusty service. And accordingly, we have taken, and this morning we have filed a Dusty affidavit, Lordship. So, Lordship, kindly this matter may be taken up day after tomorrow, just for the declaring service upon the.
Lordship, item number 27, I have filed one IA. This Honorable Court has granted interim in item number 28. However, the person is misusing the interim granted by this Honorable Court. Therefore, I have filed item number 27.
Monday we'll have. Monday. Friday do not have too many matters, okay?
Your Lordship, yesterday one order has passed for passing the order of this for writ petition, Your Honor. Since last occasion, Tapin Sir was absent.
Lordship, you say covered matter.
Covered matter yesterday.
No, not yesterday.
Oh, the day before yesterday. Sorry, Your Lordship.
What do you want?
On Monday, Lordship.
Is it listed today?
Yes.
Item number?
Item number 22.
What do you want?
I want interim and this, since the same nature of case was side, Your Honor. Your Lordship.